President of the African Court, honorable judges, distinguished delegates, you're most welcome to the second annual East African Court of Justice Judicial Conference. We apologize for the delay, but we will be starting in the next 7 minutes. I kindly request for your patience as we wait for the chief guest to arrive. Thank you very much. chairperson of the EAC Council of Ministers, Your Lordship, Lady Justice Iman Aboud, the President of the African Court on Human and People's Rights, Your Lordship, Justice Nestor Kayobera, the President of the East African Court of Justice, Your Lordship, Justice Chan Rich Madut, the Chief Justice of the Republic of South Sudan, Your Lordship, Justice Emmanuel Gateretse, the Chief Justice of the Republic of Burundi, Your Lordship, Justice Bashir Yusuf Ahmed, the Chief Justice of the Federal Republic of Somalia, who is also our special guest, Your Lordship, Justice Geoffrey Kiriawire, Judge of the Court of Appeal of the Republic of Uganda, who is also representing the Chief Justice of the Republic of Uganda, Your Lordships, judges from the National Courts of Judicature of the EAC partner states, Your Lordships, the judges of the East African Court of Justice, members of the Diplomatic Corps, distinguished delegates, ladies and gentlemen, all protocols observed. Your Excellencies, Your Lordships, distinguished delegates, I have the distinct privilege and honor to welcome you all to the second annual East African Court of Justice Judicial Conference. My name is Christine Mutimura, and I'm the Deputy Registrar of the East African Court of Justice, and I shall be chairing this conference, assisted by His Worship Registrar Jameson Karimani from the Uganda's Courts of Judicature. The second annual East African Court of Justice Judicial Conference has been convened with a distinct objective to stimulate high-level conversations and discussions on current and emerging legal and judicial issues between judges, legal practitioners, other court users, as well as representatives of civil society organizations, the private sector, and representatives of the academia in the region. From this conference, we expect that there'll be an increase in the collaboration between national judiciaries and the East African Court of Justice. There'll be an increased knowledge and awareness amongst judges, judicial officers, and legal practitioners on their role in enhancing access to justice for cross-border trade disputes. We also look forward to having an improved understanding of the professional and ethical issues at the intersection of relations between judges and lawyers, to mention but a few. Allow me, Your Excellencies, Your Lordships, distinguished delegates, to briefly take you through the program of the conference. We have before us the program, and I'd like to draw you to page 8 of the program, which is where the program of this conference begins. We shall have a keynote lecture that will be delivered by Dr. Businje Kabumba from Makerere University. We were expected to have a panel of Chief Justices and the Presidents of the East African Court of Justice and the African Court on Human and People's Rights. However, we have been requested to move this panel to the last day of the conference to allow all the Chief Justices currently in Uganda to participate in this panel. We have the program as set, and what will happen now is that we'll have session 3 come in the afternoon, but we have a session on the modernization of courts, shared experiences on the digitization, which is session 7, and that will come once we have got responses to the keynote speech. The participants on this panel have been accordingly briefed, and we shall proceed with the program as adjusted. I also want to draw your attention to the last day, and also to mention that His Excellency, the President of Uganda, President Yoweri Kaguta Museveni, shall be closing this conference officially. The program as it stands is going to be amended, and I thought I would bring this to the attention of all the delegates, that what you have as page 13 is not the final program. And the program for that very day will be shared with you before the day 3 of the conference. Without wasting time, I would like to invite retired Justice Ogola to come forward. Justice Ogola shall be moderating this next session, where we shall receive the keynote speech. And maybe in brief, I could just talk about Justice Ogola. Retired Justice Ogola is a former judge of the East African Court of Justice, who is currently undertaking, my Lord, may I request that you take your seat at the front? Thank you. Justice Ogola was a former judge of the East African Court of Justice. He also served as a judge in the Ugandan Court of Judicature. He currently undertakes various consultancies in law, and he's also a canon of the Anglican Church of Uganda. He is a holder of a Master of Laws from Columbia University in New York, and also a holder of a Bachelor of Laws degree from University of Dar es Salaam in Tanzania. Justice Ogola has also served as a judge of the Comesa Court of Justice, and from this you'll realize that he has vast experience, not only in the national courts, but also in the regional courts around the continent. You'll also realize that in the program, I believe on the last, on the cover page, the inside of the last cover page of the program, there is a poem. And this poem is titled Happy Birthday, ESCJ. And this was a poem that was composed by the retired Justice Ogola in celebration of the ESCJ's 20 years of existence. Justice Ogola, you're most welcome. May I request the keynote speaker to please come and sit at the front? Thank you.
Where do you want to sit? There?
It's fine. Okay. But did you want me to close that?
But no, you think you have to stick.
The social distance.
Sorry.
My apologies, Justice Ogola and the keynote speaker. I think my nerves took the best of me. May I request that we revisit the program, and I will request that Ms. Joyce Sabalo come and give her remarks. And after Ms. Joyce gives her remarks, we're going to get remarks from Honorable Justice Kiriabwire, who is representing the Chief Justice of Uganda. Right after that, we'll get remarks from my lady Justice Imana Bud, the President of the African Court of Justice. Right after that, we'll get remarks from the Chairperson of the Council, Ambassador Ezekiel Nibigira, and we will have remarks from the President of the East African Court of Justice, who will invite the first Deputy Prime Minister and Minister of EAC Affairs. My apologies once again. Thank you very much. You may continue. You may stay seated where you are. Yes, please.
In football, they call this offside.
Honorable Rebecca Kadaga, the first Deputy Prime Minister and Minister of East African Community Affairs, Uganda. Honorable Ambassador Ezekiel Nibigira, Chairperson of the East African Council of Ministers. Your Lordship, Judge President, Honorable Justice Nestor Kayobera, the East African Court of Justice. National and regional judges present. the representative of the government from the East African partner states, private sector, civil society, and professional association present, representative of the development partners present here, media representative, distinguished ladies and gentlemen, all protocol observed. On behalf of GIZ ESC program represented by the cluster coordinator, whom I'm happy to stand here to represent, Mrs. Gogia Beyarosh, I would like to thank the Republic of Uganda for hosting the second annual East African Court of Justice Judicial Conference under the theme, Transforming Access to Justice in ESC. GIZ and the delegates feel warmly welcome, and we are enjoying our stay in the Pearl of Africa. And we look forward to another excellent hosting where we will be looking at the recommendations that we have agreed on at this conference. We also thank the ESCJ Secretariat under your Lordship, Justice Nestor, and her Worship, Christine Mutibira, for organizing this excellent conference where we will be discussing key issues with regards to access to justice. The event would have not been possible without the support from all the development partners and the participation of the key stakeholders present, and we really applaud this. I would like to recognize and appreciate the important role played by the private sector and civil society organizations represented by the East African Business Council and the national associations present here, the civil society organization and professional association, ELS, and the team, who have taken time out of their busy schedule to come and contribute to the discussions towards transforming access to justice in the region. Because access to justice is a multi-stakeholder dimension which requires inclusive participation of all stakeholders. Therefore, we appreciate your contribution towards this cause, and I wish you well in this discussion. Ladies and gentlemen, as an institution, we support the East African community to a market-driven and people-centered integration through our program, and we appreciate all the partner states for strengthening the engagement of all the stakeholders in access to justice process, but in the integration process in general, especially the involvement of all the key stakeholders, because without this, the fundamental principle of the integration would not be achieved. So we applaud this initiative. ESC-GIZ support the ESC Secretariat in deepening the socio-economic integration of the ESC partner states by promoting trade, digital education, value addition, health and natural resource management, as well as mainstreaming the involvement of key stakeholders in the regional trade and employment. We contribute to the social and economic well-being of the ESC citizens, as well as peace and security in the region. The ESC-GIZ support to market-driven and people-centered integration program has contributed to the development and translation into 5 languages, the ESC Simplified Guide for Small-Scale and Medium-Sized Enterprises on Perishable Agricultural Goods to increase awareness, and know how to use them to foster cross-border integration and trade. The program has also supported the ESC Secretariat to empower the women cross-border traders through the publication of simplified information packages, where we have cross-border regulations, free movement of goods and services and people, so that the citizens can grasp it, digest, and use it more easily. We believe that it is important for the East African citizens, including women and youth, doing cross-border trade to know and use these simplified ESC rules, regulations, procedures of trading across the ESC. Ladies and gentlemen, over the next 3 days, we will be discussing a lot of issues and topics around transformation of access to justice in our region. We will come up with relevant policy gaps and recommendations on access to justice, which will explore topics like equality before the law, the roles of national and regional courts in bridging the gaps to access to justice, in cross-border trade, affecting social change and political dialogue, looking at alternative dispute resolution, internet as enabler of freedom of expression, public debate, modernization of courts, and judicial resource limitation, among others. It is my sincere hope that these identified gaps and recommendations will be taken up and acted upon by the relevant institutions for the benefits of East African. And I'm very much aware that our Prime Minister, Honorable Rebecca Kadaga, is an action lady, whereby when recommendations are presented, together with the chair of the council present, they will take this up and to ensure that these recommendations are taken up. So I call upon us to produce those quality policy recommendations that our policymakers can take these up. The involvement of stakeholders in the promotion of good governance and access to justice is different in different aspects of socioeconomic development of our region, is very important, both at individual and institutional level, for the promotion of inclusive, peaceful, and prosperous East African region. I thank all the stakeholders present here who are greatly contributing towards making ES integration more than just empty words for the citizens. We applaud you and ask that you continue with the good work. As the integration process advances, the sustainable inclusion and engagement of stakeholders at all levels of society remain one of the biggest challenges, and this is where good governance and access to justice fuse together, where we have to really amend. And I urge all of us to scale up the significant progress made towards access to justice in the region, and also continue with the good work that the East African will be proud of what we have done. I don't want to say much. I wish you a fruitful deliberation, and thank you for listening. Asanteni sana, webale nyo, and merci beaucoup.
Thank you very much, Ms. Joyce Sabalo. May I kindly request the Honorable Justice Geoffrey Kiriabwire to come forward and give his remarks.
Thank you very much, EMC, Registrar of the East African Court of Justice, the Right Honorable First Deputy Prime Minister of Uganda and Minister of East African Affairs, Honorable Rebecca Alitwala Kadaga. I just want to start by creating a disclaimer for the avoidance of doubt. I am not Alphonse Owinjidolo Chigamoy, Chief Justice of Uganda, but he has requested me to pass on his apologies for not being here. He is engaged at another conference, as you are aware, but he has passed on a speech for which I will read. But on my own behalf, let me also welcome all of you to Uganda, and not to be well done. Karibuni sana, bienvenue, Kampala, Al-Halan, and can we also say tubasanyukidde. Welcome to Uganda. The Honorable, the Chief Justice of Uganda's speech runs as follows. The Right Honorable Rebecca Alitwala Kadaga, First Deputy Prime Minister and Minister of East African Affairs for Uganda, the President of the East African Court of Justice, the Chief Justices of the East African member states, and we take great pleasure in also seeing the Chief Justice of Somalia with us today, the Chairperson of the East African Community Council of Ministers, honorable members of Parliament present, learned Attorney Generals of the East African partner states present, honorable justices and judges of the regional courts, honorable justices and judges of the courts of the community, honorable members of the East African Legislative Assembly, Your Excellencies, ambassadors and high commissioners, distinguished jurists and members of civil society organizations, invited guests, ladies and gentlemen. I am greatly honored to welcome you to the second East African Court of Justice Judicial Conference 2022, and to particularly thank you for gracing this very important event. And this is in spite of your very busy schedules. We would like to acknowledge the steps taken by the summit in promoting regional unity and revamping the East African community, which clearly speaks for itself. We are also grateful that the East African Court of Justice was revived and the judiciaries of the East African member states are able to meet together and share the challenges and best practices for better justice delivery in our region. Allow me, in a special way, to welcome my Lord Honorable Justice Nestor Kayobera, the Judge President of the East African Court of Justice, and heartily thank you, sir, for organizing this important conference in Kampala, Uganda. The conference is strategically organized at a time when the East African community has received new members and from diverse legal jurisdictions. I believe this conference will pave a way for us to mutually share the legal space in spite of our diversity in a bid to follow with the obligations of the treaty, which read to rise the standards of living of African peoples, maintain and enhance economic stability, foster close and ensure peaceful relations amongst African states, and to accelerate the successive stages in the realization of the proposed East African community and political union. End of quote. I'd like to take the pleasure to welcome my colleagues, the Chief Justices and judges of regional courts from the EAC member states. Welcome. I'd like to welcome honorable ministers, honorable learned attorney generals, distinguished jurists, and members of the bar, and all delegates who have graced this conference. You're welcome, and thank you for honoring our invitation. Uganda is currently battling the Ebola infection in some parts of the land. However, I wish to assure you that our medical experts are doing a commendable job. Nonetheless, we encourage that you take due precaution, just observe hand hygiene and other precautions. And in a case of fevers or symptoms, they should be immediately reported to our staff for immediate attention. Otherwise, we again thank you and heartily welcome you to the Pearl of Africa. This year's conference is premised on the theme, Transforming Access to Justice in the East African Community. This is in line with our transformation agenda for the judiciary. In order to make the rule of law more tangible in our lives, we are redirecting our efforts towards enhancing access to justice across Uganda. We have launched the Electronic Court Case Management Information System, which here we call ICMIS, to help our peoples file their cases from wherever they choose and be able to access court notices, decisions, and status reports without necessarily visiting the courts. We're working on enhancing the capacity of our human resources, both in numbers and professional skill. In addition to establishing and constructing more courts across the country. Bringing the East African Court of Justice to Kampala to handle sessions on our land this November 2022 is a very welcome development, as it will not only bring justice services nearer to our people, but it will inevitably also equip our legal practitioners and judicial officers with contemporary jurisprudence in the community affairs. And so again, we say, Karibuni sana. As you all know, the existing borders were superficial creations imposed by the colonialists for administrative and selfish reasons. Our increased interactions in search for markets, security, education, jobs, food, and other relations has made the need for the East African community an indispensable reality. These natural human relations inevitably give rise to cross-border disputes that call for our careful consideration. The power and position of the East African Court of Justice is therefore pivotal to the success of these efforts. The conference will help us decide whether it is time to clothe the court with enhanced jurisdiction, as did the defunct East African Court of Appeal, or to keep it where it is right now. I'm pleased to note, learning from the experience of COVID-19 pandemic, that the East African Court of Justice emphasized the use of technology in delivery of justice, and commendable output has been registered by that court using ICT. From the topics due for discussion during the conference, I have noted with particular interest planned panel discussions on the harnessing from mixed legal systems, managing cross-border disputes, advancing the use of ADR in adjudication, digitization of the courts, and the increased use of the internet, as well as judiciary survival amid limited resources. Looking at these well-thought-out topics and the judicial impact it would have, if we found answers, I can only end my remarks here so that more room is created for us to deliberate on the general matters. Let me express my gratitude to the leadership of the East African Court of Justice for the confidence bestowed upon Uganda to hold and host this judicial conference. I also wish to thank His Excellency, the President of Uganda, and the entire government of Uganda for accepting to host the conference and for providing the necessary support that has enabled us to successfully congregate here, deliberate on contemporary issues of mutual importance. Finally, I heartily thank each one of you, our esteemed guests, for coming to Uganda to share with us your vast judicial experience and best practices. I wish you a pleasant stay here in the Pearl of Africa and a successful conference. For God and my country, Alphonse Chigamoy Owinjdolo, Chief Justice of Uganda. I thank you.
Thank you very much, my Lord, for delivering the remarks of the Honorable Chief Justice. We want to appreciate once again the assistance that has been extended to the East African Court of Justice by the Chief Justice. The success of this event in many ways, and the preparations that have led up to what we have today, it is because of the assistance and the good cooperation we've received from the judiciary of Uganda. May I kindly request the President of the African Court of Justice, my Lady Justice Imana Bud, to come forward and make your remarks.
Thank you. Just to make the record clear, let me say I'm the President of the African Court on Human and People's Rights. Your Excellency, the guests of honor, Rebecca Alitwala Kadaga, the First Deputy Prime Minister and Minister of East Africa Community Affairs of the Republic of Uganda. Please allow me to stand on the existing protocol just to save our time. Good morning to all. It is indeed a great pleasure for me as a President of the African Court on Human and People's Rights, and in fact for the African Court to be represented at this very important meeting and to be given the opportunity to speak at the opening ceremony. It is an opportunity for us to use this platform, the second annual East African Court of Justice Judicial Conference, to not only share with you, but to also showcase the very plausible work that the African Court has done on the continent in the protection of human rights in general and promoting access to justice in particular, since it became operational in 2006. The African Court and the East African Court of Justice, as sister institutions, which share the noble task of administering justice to the public. In 2019, the two courts signed a memorandum of understanding to strengthen their relationship and explore better ways to enhance promotion and protection of human rights, access to justice, respect for rule of law, and advance good governance in the region and the continent as a whole. Distinguished participants, access to justice has been described as the most fundamental of rights that we have, and without it, our other rights, be they right to property, right under contract, public law rights, or human rights, are chimerical. Access to justice is not just a right in itself. It is the key enabler for making other fundamental rights a reality. It is incumbent on all of us to do all we can to ensure that access to justice is such a reality. The theme of this Judicial Conference is transforming access to justice in East Africa. Transformation simply means change, and I guess positive change. The change which is therefore desired from this conference is change which will improve access to justice for citizens of the East African community. Since the advent of constitutional democracy, member states of East African community, and in particular the legal profession and the judiciaries of these countries, have transformed in a variety of ways. However, transformation is an ongoing process, or as some would say, a working progress. And so a number of challenges still stand in the way on the legal profession and judiciary in the region to ensure effective access to justice to the public. It is only through access of legal service that East Africans can fully enjoy the rights enshrined in their state constitutions and international human rights instruments. The general factor that prevent people from accessing justice include, but are not limited to, high cost of legal services, uneven geographical distribution of lawyers, lack of recognition of the role played by paralegal practitioners, lack of information about the availability of legal service, the intimidation image that lawyers have, lack of different legal insurance scheme, limited effectiveness of state's legal aid scheme. Many lawyers fail to provide community service, partially understanding of laws, lack of appropriate tools to implement them, lack of knowledge of emerging technological issues to judges, judicial officers, and court users. Furthermore, the distribution of practicing lawyers who deliver legal service to the public is skewed. Most lawyers practice in cities, and they save corporations and wealthy people. There are very few lawyers who serve the areas of township and rural settlements, and those that do generally have poor resources. The practicing lawyers are not sufficiently involved in providing legal aid service to poor persons. Distinguished participants, the lack of information about legal service could be addressed through public awareness campaign in the media, increasing advertising on the part of practitioners, the development of street law programs, and the provision of information to the public by professional bodies and legal aid boards. What is important in the fact that lawyers should be encouraged to play a role in community life and speak to community groups about the service they provide and the help they can offer. Awareness should also be raised around the fact that most East African universities have legal aid clinics to help persons or communities who cannot afford legal services. The goal of transformation must be to have a legal profession which represents the diversity of the East African society in all branches and at all levels. To achieve this, we must ensure that disadvantaged graduates have the same opportunities to become successful as to advantaged graduates. We must ensure that they are set up for success. Lecturers and students exchange schemes should be established. Joint programs with well-established law schools encouraged. Our courts should offer vocational internship to students from law schools. In the line with the theme of this judicial conference, the East African Community and East African Court of Justice must always bear in mind that access to justice is a key tenet of the rule of law. All members and their nationals have a fundamental right to access legal services, regardless of their means, and the justice system may become meaningless if there are barriers that prevent people from enforcing their rights. True equality requires that all these barriers, financial, social, and cultural, be removed for all. The legal assistance system is critical in overcoming these barriers. Ensuring access to justice for the economically and socially disadvantaged members of our community is the responsibility of all states and governments. Distinguished participants, the African Charter on Human and People's Rights, the main human rights instrument on the continent, does not expressly provide for access to justice and the rule of law, either as a principle or as a right. However, several rights or principles guaranteed in this charter are elements of access to justice and the rule of law, such as equality, non-discrimination, fair trial, legality, and proportionality. The African Court on Human and People's Rights has made significant contribution to safeguard fundamental rights and freedom in Africa in the past 16 years. It has adjudicated matters involving various issues and likely fair trial, the right to political participation, such as participation in elections, and the operation of electoral bodies, the right to life in connection to the mandatory imposition of the death penalty, the right to nationality, freedom of expression, as well as women's rights. It may be useful at this point to share with you some landmark cases delivered by the court that have made significant advances in the protection of human rights in general and promotion of access to justice in particular on the continent. All these cases can be downloaded from our website. In a number of cases against Tanzania, the court has held that the lack of legal representation for serious offenses might constitute violation of the right to fair trial and might constitute a denial of access to justice. The court ruled in these cases that where an accused person is charged with a serious criminal offense that carries a heavy sentence, he or she has a right to free legal assistance in order to give effect to the right to defend oneself. According to the court, this right is not contingent on the individual requesting for the said assistance. Rather, the respondent state has an obligation under Article 7(1)(c) of the Charter as read together with Article 14, 3D of the ICCPR to render the free legal assistance. There are many number of cases in Tanzania that against Tanzania, which I'll just mention a few. There's application 005 of 2013, Alex Thomas versus Tanzania. Application 006 of 2013, Wilfred Onyango, Nyangi, and others in versus Tanzania. Application 004 of 2016, Evidus Rutechura versus Tanzania, right to free, which involves right to free legal assistance does not, which says right to free legal assistance does not mean that the individual has a right to choose the counsel to represent them. In Abduleya Nikema, Ernest Zongo, Blaise Iluboda, and Burkina Faso Human Rights People's Rights Movement versus the Republic of Burkina Faso, the court held that where the respondent state does not act with due diligence to find, prosecute, and punish the perpetrators of the crime or murder, it may be said to have violated the right of the applicant or applicants to have his or her or their cause heard in violation of Article 7 of the African Charter. In Hunge Eric versus Benin, the court stated that the right to effective remedy has 3 components, including the fact that the remedy must be effective in the sense that the person concerned has really access to a court. In Sebastian Germain Ajavo versus Benin, the court held that a system that does not provide for the possibility of appeal is a violation of the right to fair trial. To give credence to this important element, in the administration of justice, the African Court has adopted a legal aid policy and instituted a legal aid scheme to provide legal assistance to indigent applicants that appear before the court. To this end, the African Court has embarked on a training of advocates or counsels and has so far trained over 100 across the continent on how to access and litigate before the court. That means the African Court. I take this opportunity to call on those legal counsel in the region who may not be aware of this initiative to register on the court's roster to provide legal aid service to indigent applicants before the court. To be registered is quite simple. One only has to complete the registration form on the court's website. The requirements are that one must be a national of African Union member state, be entitled to practice in any AU member state or before international tribunals, and possess at least 5 years of the professional experience. The next training, just to share with you, is scheduled for July-August 2023. Distinguished participants, before I close, permit me to once again express my sincere appreciation to the organizers of this meeting, in particular to my brother, the President of the East African Court of Justice. And I think this should be our spirit. While thinking of transforming access to justice, I add our sister court, the East African Court of Justice, to note that access by litigants is a key to the discharge of our mandates. We must thus strive to ensure that we enroll and facilitate access to our courts of quality lawyers from all over the continent. In the same vein, we must make the judges, we must make capacity development of a permanent future of our courts so as to keep the judges, staff, court users, and the legal practitioners regularly updated with the knowledge of the law and practice before our courts. I thank you for your kind attention. Asanteni sana kwa kunisikiliza.
Thank you very much, Your Lordship, Justice Iman Aboud, the President of the African Court on Human and People's Rights. Before I can invite the chairperson of the council and the Minister of EAC Affairs from the Republic of Burundi, I want to acknowledge the presence of judges from the Republic of Burundi, judges from the Republic of Rwanda, judges from the Republic of Kenya, as well as the Chief Registrar of the Kenya Judiciary. I also want to recognize judges from the South Sudan. I wish to also recognize judges from the Republic of Uganda, our hosts today, as well as the registrars. With that, I would like to invite the chairperson of the council to come and give us his remarks. Thank you.
Right Honorable Rebecca Alitwala Kadaga, First Deputy Prime Minister and Minister of EAC Affairs of the Republic of Uganda, the guest of honor, Honorable Bashe Yusuf Ahmed, Chief Justice of the Republic of Somalia, Honorable Chief Justice of the Republic of South Sudan, Honorable Chief Justice of the Republic of Burundi, Honorable President of the African Court of Human and People's Rights, representatives of the Chief Justices of the Republics of Kenya, Rwanda, Democratic Republic of Congo, and the United Republic of Tanzania, honorable members of EALA here present, and the Uganda Parliament, heads of EAC institutions, government officials from the EAC partner states, development partners, legal practitioners, members of the academia, civil society organizations, private sector and the media EAC staff, distinguished participants, ladies and gentlemen, all protocol observed. A very good morning to you all. My humble honor and the privilege to be here with you at the second annual EACJ Judicial Conference under the theme, Transforming Access to Justice in EAC. My Lord, Honorable Judge President of the East African Court of Justice, we appreciate the invitation to be part of the second annual EACJ Judicial Conference. I also take this opportunity to congratulate the East African Court of Justice for the initiative of holding annual judicial conferences at the end of each year. I recall last year, EACJ Judicial Conference held in Bujumbura, Burundi, in celebrating the Kurta 20th anniversary, and again this one that we are gathered here today. Indeed, these are special events in the record of the East African Court of Justice. The judicial conferences afford opportunity to reflect on the yearly operations of the court, success, challenges, and brainstorm on the way forward to continue delivering justice to East Africans in accordance to the EAC Treaty mandate. In a special manner, I take this opportunity to thank the government of the Republic of Uganda for accepting to host this event and supporting the East African Court of Justice in making this event a reality. We also appreciate the hospitality accorded to us as participants by the Republic of Uganda. Guests of honor, distinguished guests, ladies and gentlemen, I am aware that the ESCJ will conduct its November court sessions here in Kampala, Uganda. This is an indicator that indeed the court belongs to the people. I congratulate the ESCJ for bringing its services closer to East Africans through annual rotationally court sessions in the EAC partner states. This will increase the court visibility as majority of East Africans are still not aware of its existence and the jurisdiction. We recognize and appreciate the role of the EACJ in the EAC integration agenda. The EACJ is the judicial body of the East African community mandated to ensure adherence to law in the interpretation, application, and the compliance with the EAC Treaty. The court therefore guides the integration agenda by discharge its duty. Our role is to continue to support the court in undertaking its judicial mandates. However, there is a matter of concern that needs to be looked at, which pertains to the competencies of the courts. From some time ago, stakeholders have been questioning the extension of court competencies whereby the court seems to overtake individual national court powers. Some say that there is a tendency for national courts to lose their powers as the EACJ seems to be the ultimate and the final step of jurisdiction. They posit that the situation may jeopardize matters of sovereignty of each country. As they say, nobody can love his or her child more than her mother. This subject matter needs to be revisited at each level of leadership of the community for us to ensure that the EACJ is really contributing to enhancing the integration agenda and the respect of individual partner states' sovereignty and independence. The EACJ needs the political will and the support that will allow the body to effectively and efficiently operate. Guests of honor, distinguished guests, ladies and gentlemen, I strongly believe this judicial conference will offset conversation that brings solutions to various challenges the EACJ faces. With these few words, allow me Wish you all a fruitful conference. Thank you, and thank you.
Thank you very much, Honorable Minister and Chairperson of the Council of Ministers. As the EACJ, we want to also acknowledge the continued support of the Council of Ministers that has enabled us undertake our mandate. With those few words, I would like to invite the Honorable Justice Nestor Kayobera, the President of the East African Court of Justice, to give his remarks. My Lord Justice Kayobera, I will also request that once you have made your remarks, you invite the Honorable First Deputy Prime Minister to give her opening remarks.
Yeah, maybe before I start, let me get this opportunity to ask the Chief Justice of the Federal Republic of Somalia to come here and greet the people. You come. Others will get opportunity during the Chief Justice Forum as member states, because you are not an East African member state.
بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على رسول الله السلام عليكم ورحمة الله وبركاته. The First Deputy Prime Minister and Honorable Chief Justices, distinguished guests, good morning, everybody. Really, I'm not prepared to address the conference, but I'm really very pleased and to attend this splendid gathering and of the East African Court of Justice and second annual conference for the East African Court of Justice. And Somalia is really working very hard to join the East African community countries, and we do believe that it's a great opportunity for the Somali people and for the other member states and to join this great nations of East African community. Somalia really has been going through a chaos, civil wars, and lawlessness for a long time, for almost 3 decades. But we are now evolving from those conflicts. The country is really rebuilding now, and we are really fighting hard, militarily, economically, and ideologically, to defeat the international terrorism organization affiliated to Al-Qaeda. And hopefully, Somalia will stand on its feet in the near future, and hopefully it will defeat the terrorist organization that's really bothering the sisterly countries in East Africa and the world at large. Somalia is really reestablishing its judiciary from the scratch. We have now built the courts, we have trained judges, we have trained lawyers, and really we are improving the access to justice for the Somali people. Although some parts of the country are still controlled by Al-Shabaab, but hopefully we will defeat. And really we count on you, on the East African member states, to support the Somali people, to defeat the terrorists, and to stand on its feet. And I really thank you so much for inviting me this very important gathering that brought together very eminent personalities and jurists to share views and experiences. And the Somali judiciary is expecting to learn from you, from the eminent personalities who are here today, and we are wishing to work together. I thank you so much for inviting me and Somalia really wishes to join this East African community in the near future. Thank you so much. Thank you, Mr. President.
The Right Honorable Rebecca Alitwala Kadaga, the first Deputy Prime Minister and Minister of EAC Affairs of the Republic of Uganda. The Honorable Ambassador Ezekiel Nibigira, the Chairperson of the East African Council of Ministers and the Minister in charge of EAC Affairs of the Republic of Burundi. The Honorable Permanent Secretaries, the Attorneys Generals from the partner states of our community. My sister, the President of the African Court of Human and People's Rights, the judges from the East African Court of Justice, my brother, the Chief Justice of the Republic of South Sudan, and my brother Emmanuel Gateretse, the President of the Supreme Court of the Republic of Burundi, the judges from African Court, of the East African Court of Justice and from the judiciary of the Republic of Uganda, very high senior government officials, members of parliaments of Uganda, but also members of EALA who are present, the heads of institutions of the East African community, our development partners, the legal practitioners, members of academia who are present, the civil society organizations present, the private sector and the media all are here. Yesterday we had a training of media people from all the partner states, the East African community staff, and also from our court, the staff from our court, the distinguished participants, ladies and gentlemen, all protocols observed. I wish to thank, first of all, God for travel mercies and having allowed us to convene for this auspicious second annual East Africa Court of Justice Judicial Conference. It is my pleasure to welcome you all to this second East Africa Court of Justice Judicial Conference. We feel honored to have secured time to participate and do not take your presence for granted. I also take this opportunity to thank the government of the Republic of Uganda for tremendous support and the collaboration in making this event happen, and for the hospitality accorded to us and all participants during this occasion. I know, in a special way, the first Deputy Prime Minister and Minister in charge of East African Affairs had been working hardly, because before we organized this one, we had a meeting with her. She received our team. We had a meeting with the Speaker of Parliament. We had a meeting of the Attorney General from here. We also met with the Chief Justice. So we discussed, and really she took this matter into her hands. We thank you very much, ma'am. I also take this opportunity to thank the Right Honorable First Deputy Prime Minister. Sincerely, I know you have been working very hard with your team. My sister, the PS, from when we have been here, and the team of the organized team, local team here, which has been working with our team. But in a special manner, I take this opportunity to thank His Excellency, the President of the Republic of Uganda, the Honorable Yoweri Kaguta Museveni, for accepting to host this second East African Court of Justice Judicial Conference, and to find time to be personally present at the closing of the event on Friday, 28th October this year. You know, there is the Women Judges Association, which is taking place in Munyonyo. So there are other Chief Justices who are there, but also the President also went to open the conference. Distinguished guests, ladies and gentlemen, I want to express my sincere gratitude on behalf of our court to all our funders, namely the government of Uganda, GIZ, IDLO, UNESCO, Synergy International, Sweden, Sverige, CAS, and RWI for the support accorded to our court in making this second annual judicial conference a reality. We highly value your contributions, and we look forward towards future cooperation. Allow me to extend my great appreciation to all EAC heads of organized institutions, led by my brothers, Dr. Peter Mathuki, the Secretary General of the EAC. Now he would have been here, but today he has an appointment with the president of Somalia. So, but also with the Speaker of the Nation of the EYALA for their committed support to our court and the team spirit built among us as heads of organs. I also appreciate the goodwill of the partner states in implementing the decision of this court, which is assurance of respect to the rule of law and indication of the independence of our court as a judicial organ of the community, which is mandated to ensure adherence to the law in the interpretation, application, in accordance with the treaty as provided for under Article 23(1) of the treaty. Distinguished guests, when the court started in November 2001, it spent 4 years without a single case filed. The first case was filed in 2005. The 4 years' time allowed the court to set its feet on ground by drafting and adopting its rules of procedures. Initially, the court started as a single chamber with the 6 judges. However, after the famous Anyang' Nyong'o case, when the Republic of Kenya did not have a place to appeal, the East African Community Summit of the Heads of State decided to establish the appellate division of this court. The Anyang' Nyong'o case is therefore a historic one in the life of the court. Today, the story is different. The court has 2 divisions. The first is a division and the appellate division. The first instance hears and determines the cases at the first instance, subject to a right of appeal to the appellate division. Currently, 6 judges serve at the first instance division and 5 at the appellate division. However, the East African Community Treaty provides for a maximum of 15 judges, 10 judges for the first instance division and 5 for the appellate division. And due to the limited number provided under the treaty, newly admitted members of the community cannot nominate a judge to the appellate division until the treaty is amended. The court's growth has therefore flourished in these 21 years of its existence. And the following cannot go unnoticed: increasing number of cases filed, developed jurisprudence, increased visibility and access to the court through sub-registry offices developed of case management and the recording systems and the digital advancements. During the COVID-19 pandemic, the court continued its business without interruption, accelerating its use of technology. Litigants filed cases online, trials were conducted online, witness evidence were received via video link, judges used e-signature to sign judgments, etc. All this impacted on the effectiveness and efficiency of the court. From 2nd November to 2nd December this year, the 2 divisions of this court will hold their sessions here in Kampala. And cases to be heard and determined during the sessions are coming from all the partner states, and others are coming from the community. This is to bring justice closer to the East African people. And majority of East Africans are not aware of the existence and the jurisdiction of the court. The East African Court of Justice highly appreciates the government of Uganda for accepting our November sessions to be held within the premises of the Commercial Court of the Republic of Uganda. This shows the goodwill of the partner states to enable East Africans know and enjoy the fruits of justice in the integration process. Tunamshukuru sana mzee. I am also cognizant of the fact that despite the achievements of the court, has over the years experienced limited and inadequate budgetary allocation, the nature of court operation, and the reliance on ad hoc service of the judges had impacted negatively on the overall performance of the court. It is indeed regrettable that there has been delay in establishing and operationalizing the court's administration and financial autonomy, even after the bill has been adopted by the Council of Ministers. Distinguished guests, ladies and gentlemen, despite the challenges, I, however, wish to congratulate all learned counsels, private and government lawyers, as well as the counsel to the African Eastern Community, CTC for their contributions in enriching the jurisprudence of the court and for their role in upholding the rule of law and access to justice. In a special note, I wish to thank the Attorney General of the Republic of Uganda because he has been appearing personally in court with his lawyers and has been defending the government of Uganda, personally appearing to court. And this also gives the value to this court. Because the minister said there are others who think the court is interfering with the sovereignty of the partner states. It is not true. Because the court decided, when we took our oath, we said that the court, as judges, we do our mandate without fear, without favor, and also without interference. To my fellow East African judges, the current and the retired judges, your contribution to the East African Court of Justice has demonstrated the confidence and the trust the people of East Africa have in our court. To the staff of the court, your valuable professional, technical contributions and dedication made possible the achievements we are proud of today. On the same note, I wish to thank the national judiciaries through the Honorable Chief Justices, where the East African Court of Justice relationship has continued to grow stronger and stronger. To the Chief Justices Forum, the Chief Justices Forum and the East African Magistrates and Judges Association have been some of the platforms to discuss and lay strategies to strengthen the judicial systems, both at national and regional level. Indeed, this Judicial Conference is a special event in the record of the East African Court of Justice. It affords an opportunity to reflect not only on its one-year journey, but also from the inception to date. I believe the second annual East African Court of Justice Judicial Conference will offset conversations that will strengthen the capacities of judges, judicial officers, and court users in responding to various challenges faced by justice seekers, as well as identifying areas of interest for national and regional judiciaries. The expected output being as follows: to increase collaboration between national judiciaries and our court, to increase knowledge and awareness among judges, judicial officers, and the legal practitioners on their role in enhancing access to justice for cross-border trade disputes, to improve understanding on the role of the internet as an enabler of freedom of expression and right to information, to improve understanding of the critical role of courts in effecting social and political change, to improve understanding of the professional and ethical issues at the intersection of relations between judges and the lawyers. It is without doubt, I believe, the methodology in place will enhance the achievement of the objectives of this second East African Court of Justice Judicial Conference. With these few remarks, I wish to welcome, Ma'am, the Right Honorable Rebecca Alitwala Kadaga, the first Deputy Prime Minister and Minister of East African Affairs of the Republic of Uganda, to humbly come and officiate this conference. Karibu sana, ma'am.
Thank you very much, Judge President. The Honorable Niwigira, Chair of the Council of Ministers, the different judges present. I think for the rest I'll stand on the distinct protocol in case I make mistakes. But I want to welcome all of you to Uganda. I'll start by saying habari za asubuhi, bonjour, and good morning. I want to, on behalf of the government of Uganda, to add my welcome to that of Justice Kirawire and the others and to say thank you for the honor to host you in our country. This morning I was telling Judge Kayobera that this week is a judicial week in Uganda because of the 3 judicial conferences taking place in the country. As you heard, the women judges in Uganda. We also have the IGAD conference on land conflicts, which has also taken place in the country. And of course, we are here. So thank you really for the honor to host you in our country. It's a pleasure to be here for the 2nd annual East African Judicial Conference. And let me thank very much the East African Court of Justice, the leadership and management for making it possible to assemble here. I commend you because this started in Bujumbura last year, and I think it's important that we continue. Let me acknowledge the work done within all the partner states to promote the integration. And I want at this stage to congratulate the people of Kenya on concluding successfully presidential parliamentary elections, establishing their new government, and to thank Justice Martha Koome and the Supreme Court of Kenya for expeditiously and effectively handling an election petition in record time. The community has grown, as you have been informed. We now have, seriously, a meeting of the Commonwealth legal system and the Code Civil system. So we need to find ways of coexisting and working together. It requires improving the structures of collaboration amongst our partner states. As you have been told, this court is an important organ of the East African community. I'm happy that the jurisdiction of this court has now been enlarged to include arbitration of issues of the customs union and the common market protocol, which are very central to the lives of the people of the East African community, and I look forward to increased activity in this court. We're here to discuss under the theme, transforming access to justice in the East African community. The partner states have an obligation to enhance this cooperation in legal and judicial matters through harmonization of legal trainings and certification, standardization of judgments of courts, and publication of all reports for jurisprudential purposes. I am aware that the Court of Justice has done a commendable job in passing judgments that have impacted human rights jurisprudence in the region and strengthened within the community. Therefore, it's our obligation to pursue this relentlessly to ensure that we have meaningful realization. Perhaps one of the areas which will not be directly in your hands is the standardization. We still have trouble in some partner states where qualifications are not necessarily acceptable. They are not being standardized as yet, and yet our citizens are studying in all our jurisdictions and expect to practice in all of them. So that area is one of those that we need to work hard to ensure that it facilitates the common market protocol. Therefore, this conference seeking to strengthen the collaboration between the national judiciaries and the East African Court of Justice. It will increase awareness among the judges about the judicial, it will increase collaboration between the judicial officers, the legal practitioners. I think in my practice, it was very rare to see Kenyan lawyers come to practice here except in election petitions. It was rare to see Tanzanian lawyers coming here to practice before our courts. But now, Justice Kayobera and the ACJ will make it possible during November for the citizens of Uganda to see all these foreign lawyers coming here to handle cases on behalf of the people of East Africa. This is again part of our collaboration to increase integration. I'm aware that the number of cases have been court listed. I know that there are some cases for first hearing. There are cases where rulings are going to be delivered. There are cases which are going to be scheduled. All these are things that will be of interest to the people of East Africa and to show that work is ongoing. I've noted the issues raised by Judge Kayobera on the budget, on the ad hoc nature, the need to amend the treaty. I'm glad I've come with my colleague, the minister, the chair of the Council of Ministers. I think we shall now be given an impetus to work harder to ensure that we respond to the needs of the people of the region. Uganda is fully committed to supporting the ESCJ, and as you have heard, we bent over backwards to ensure that this sitting can take place, and also that the sitting of the courts can take place at our commercial division. And let me thank the Chief Justice and his team for making that possible. And maybe just for the interest of for our friends, that the Republic of Uganda is taking very seriously the issue of integration. Starting on Monday, the entire cabinet is going to start training in Swahili, now officially. Starting on Monday next week, from 9 to 10 every Monday, we shall be taking lessons in Swahili. I'm sure you're aware that in this region, we are really the ones who are performing. So in about a year's time, we shall be able to speak to you and write to you in the Swahili language. So let me conclude by inviting you, since the meeting ends on a weekend, I want to remind you that this is the land of the source of the Nile. It's the land of the Crater Lakes. It's the land of the Rift Valley. It's the land of the Uganda Matters. And for those inclined religiously, on Saturday, we are celebrating the martyrdom of Bishop James Huntington in Chando. So you can really come with us on Saturday, and we go to celebrate one of our martyrs in Mayuge district with His Excellency the President and the people of Uganda. So on that note, I want to welcome you again. Thank you for coming to Uganda, and to declare this meeting officially open, and wish you fruitful deliberations. Thank you so much.
Thank you, Right Honorable First Deputy Prime Minister. We want to say that we have received a very warm reception from Ugandans since our arrival and are having a truly Ugandan experience. I also want to say thank you to you, the First Deputy Prime Minister, and in echoing the words of the Judge President, the Ministry of EAC Affairs has been a great support to the East African Court of Justice in the preparations to this conference, and we appreciate that. Without wasting time, the next activity on the program is the photo session, and I'd like to invite my co-chair, His Worship Jameson Karamani, to come and take over this session. Thank you.
Thank you very much, Your Worship, for moderating the session. We are going into a photo session. I request the protocol team to bring us the chairs which we are going to use. We shall take in sets. The high table will be constant, and then we shall have other groups which will be joining them for different photographs. So I request the protocol team, please bring the chairs which are required here. The first photo will be for the keynote lecturer and the respondent for the keynote lecture, because they have waited for it for a while. They have taken the first one. That one will be followed by the East African Court of Justice judges. We shall have one for the heads of diplomatic corps and missions. We shall have the judges of the respective member states. We shall have one with our development partners. We shall have a photograph of the permanent secretaries and heads of government agencies present today. So I request the high table to take their seats. Protocol team, please guide our high table on how they take their seats. I request the Chief Justices who are present to join in. As I request Dr. Kabumba and His Lordship Justice Ogola to come and have the first one. You are going to stand behind. The rest will be standing behind. I think they have given chairs for you to sit. Thank you very much. Thank you very much. I now request the justices and judges of the East African Court of Justice to join in. Let them join in. The people who are seated are going to be constant. We request you to remain seated. Thank you very much. Let's request the justices and judges of the East African Court of Justice to join in. Thank you very much. Let me request the heads of diplomatic missions who are present to come and have the second photograph. Request other representatives from respective embassies to also join in for this photograph. of the members of parliament who are here. Honorable members of parliament, honorable secretaries, the next one is for our panelists, presenters, and moderators. Panelists, presenters, and moderators who are present here, please prepare to take the next one. Thank you very much. For the registrars from national courts, all the registrars who are present, kindly make your way and have the next one. Registrars present. All the registrars who are present here, from regional, national. Let's have the private sector, civil society, and academia. Private sector, association members, both national and regional, civil society and academia. The ECJ staff who are here, I know you are many, but you can be represented by those who will be inside here. We also prepare to have one, and we have the rest of the national organizing committee. It appears we have only one from the academia, civil society, private sector. Bar station members. you very much. Let's have the ECJ, East African Court of Justice staff who are present, please. I don't know whether that's the inform of the court. We thank you very much for the work that you do for the court. Thank you very much. Let's have the last one, which will be by the National Organizing Committee, led by the chairperson. Mr. Joseph, please lead your team for the frequent flights you have had to organize this. Give you a photograph. Let us be quick. They are going to have their tea. Very much for taking part of the first session. We shall be ready by midday for our keynote lecture. Thank you very much.
The program has also
Dear honorable delegates, we need to be getting ready for the next session. I do request that those who have finished taking their seat, they could make their way back to the conference room so that we can be ready to begin the next session.
what you feel in the gentle caress of tropical wind from the mountaintops, and the glow in your heart from a warm neighborly invite. It's in the distinct aroma of our cooking to the taste of food that takes you on a journey. In the sound of homecoming and the sound of Mother Earth. In the magnificence we find on our travels and the exciting moments we experience. Ours is the kind of beauty that comes in all things big and small. All we have to do is awaken our senses and truly enjoy what's uniquely ours.
My lords, distinguished ladies and gentlemen, allow me to welcome you to the next session. I request that we take our seats as we go into another session. We are going to have the keynote lecture. As earlier introduced, it will be delivered by Dr. Businje Kabumba. The moderator of that session is Honorable Justice James Ogora. Allow me at this point in time to invite the moderator of the session, this time for your starting of the lecture, and that is Honorable Justice James Ogora. My Lord, I do welcome you to once again take your seat. In the same vein, I do request Dr. Businje Kabumba to again take his seat. Without much ado, Honorable Justice James Ogora needs no much introduction. He's very much well known to all of us. He has served in the East African Court of Justice. He has been a principal judge in the National Court of Uganda. He now belongs to the Elders Forum here in Uganda. My Lord, you are welcome, and I hand over the audience to you.
Thank you very much, Worship. Let's take our places, please. We have our first substantive speaker, substantive in terms of the subject matter of this conference. I'm going to introduce him in a little while, but the topic that we have is very intriguing to me. It says, Shaping East Africa through Advancing Access to Justice. That's quite a mouthful there, quite a cluster of thoughts, concepts. I was thinking to myself, shaping, what does that mean? The other words that could have been used for shaping are things like molding, designing, creating, fashioning, or maybe even embellishing. That's what we are going to be hearing about this afternoon. But what are we shaping and molding and creating? East Africa. Now, even that is a concept. Those of you who are like me, with flowers on the top of the crown here, we remember East Africa more in terms of Uganda, not even Tanzania, but Tanganyika, and then Kenya. That metamorphosed into Uganda, Tanzania, and Kenya. And then all of that became Uganda, Kenya, Tanzania, Rwanda, Burundi. Lately, all the above have been joined by South Sudan. And very pretty soon, we may be joined by Somalia. So even the concept of East Africa and shaping it is beginning to have a lot of meaning. But then that is followed by access. We are shaping East Africa's access. And what is access? Even that is a moving target. Physical, virtual, analog, digital, all of that is accessing. And then comes the mother of all concepts, justice. And what is justice? It has many, many implications, many undercurrents to justice, theological, philosophical, political, metaphysical, ideological, and of course, jurisprudential. All those things are compacted into that one term, justice. My lords, distinguished participants, what we have before us is like an ever-running stream which keeps moving on, keeps flowing along, ever forwards, never backwards. To help us get through all of this is a distinguished presenter. Distinguished presenter, he gave me his, what they call bio. It's like 4 pages of CV. So, Dr. Kabumba, you will forgive me if I abridge this. If I were to read 4 pages of this here, we might lose our audience. But Dr. Businje Kabumba is a senior lecturer in public law at Makerere University here in Uganda. He's a holder of a doctorate of philosophy. But he started his law academic journey from Makerere, where he earned a first-class honors. And that one catapulted him into very prestigious universities, including Oxford in the UK, where he read Bachelor of Civil Law, Harvard in the USA, where he read his Masters of Laws, and then he had his postgraduate diploma here in Uganda. He has written a number of books and other publications. He has written some of them with legal legionaries in East Africa. He wrote one, for instance, with Professor Lilian Ekirikubunza Tebatemwa, a professor and a justice of the Supreme Court here in Uganda. Another one he wrote with Professor Frederick Sempebwa, who is not only a known academician, but a chair of a Constitutional Review Commission at one time here in Uganda. Dr. Kabumba is a founder partner, Development Law Associates in Uganda. He's a member of Uganda's Law Society and East Africa's Law Society. He's in the International Bar Association, Chartered Institute of Arbitrators in UK, and many other things. So, this afternoon, we have a very rich table of buffet. Let's choose our take on that menu as Dr. Kabumba, the chef, shepherds us around. Thank you very much. Tune your ears. Dr. Kabumba, the floor is all yours. Shall I give you 20 minutes or so? And then another 20 minutes for Q&A? I think that will do good justice to this topic. Thank you very much. Let's put our hands together.
Good afternoon, everyone. I'll start with the protocol. I'll probably mess it up, but I suspect that the effort is important. Your Excellency, the Right Honorable Rebecca Kadaga, First Deputy Prime Minister and Minister in charge of EAC Affairs, Uganda. Your Excellency, Ambassador Ezekiel Ibigira, Minister of EAC Affairs and Chair of the EAC Council. Your Lordship, Lord Justice Iman Aboud, President of the African Court of Human and People's Rights. Your Lordship, Honorable Nestor Kayobera, President of the EACJ. Your Lordship, Justice Chan Rich Madut, Chief Justice of the Republic of South Sudan. Your Lordship, Justice Emmanuel Garetse, Chief Justice of the Republic of Burundi. Your Lordship, Justice Bashe Yusuf Ahmed, Chief Justice of the Federal Republic of Somalia. Your Lordship, Justice Geoffrey Chirawire, Justice of the Court of Appeal and representative of the Chief Justice today. Honorable judges, present, magistrates, registrars, the moderator, retired Principal Justice James Ogola, ladies and gentlemen. When I got the kind invitation to deliver this address, it surprised me. I thank, first of all, the President of the EACJ for extending this very kind invitation. It's not one I take lightly, and I hope to do as much justice to it as I can. There was a very kind introduction that I feel has set the bar a bit high. It has worsened the burden I already felt. In accepting the invitation, I couldn't help but reflect on an interesting coincidence, though, which sort of concerns my interface with the judiciary. I realized that it seems that I interact with the judiciary every other 2 years, starting in 2016 with the East African Magistrates and Judges Association at the kind invitation of then Chief Registrar Paul Gadenya, as he then was. The 2018 Annual Judges Conference at the kind invitation of the then Chief Justice Bart Katurebe, and most recently the 2020 Benedicto Kiwanuka Memorial Lecture at the kind invitation of Chief Justice Alphonse Chigamoy Oinyidolo. Each of these occasions has allowed me the incredible opportunity to share some thoughts regarding judicial power in Uganda, and I hope to use this additional space to further this exchange of ideas. Perhaps an explanation for the frequent invitations might be that I'm an in-law to the judiciary, given that the mother of my children is a member of the judiciary in Uganda. That may be one way of looking at it. The other might be based in the African proverb that a child who washes his hands very well is allowed to to sit and eat with the elders. So it appears it might be that also I've washed my hands very well, and that may be the basis of the frequent invitations. On this occasion, I've been asked to speak on the question of shaping the East African community through advancing access to justice, and I'm keenly aware, of course, that the things you can say after 12:30 are not really the things that you can say before midday. Patience has worn thin, tempers are a little bit frayed, so I'll try to keep to the 20 minutes allocated to me as opposed to the original 30, and also try to abridge some of the longer thoughts that were in the fuller paper, which I'm sure can be shared. But just to say that I've taken the liberty, and I trust and I hope I'll be forgiven, of titling this note a bit differently, to address the question, and I've called it Not Yet Uhuru, Legal Decolonization and Access to Justice in the East African Community. Because I suspect that at the core of a lot of the manifestations of access to justice challenges, whether they be the traditional statistics about case backlog or other numerical manifestations of this certain perennial challenge, at the core of them is really a crisis of identity, a crisis of history, of memory, of who we are, where we came from, where we're headed. And perhaps then to speak to the points, the very important points made by the moderator about the changing face of East Africa and the challenges presented by this expansion. It could be that we're faced with a clash of colonialisms, that now the common law tradition, which wasn't ours, isn't ours, is interacting with the civil law tradition, which wasn't ours, isn't ours, creates a new clash, really, of new identities that are themselves not autochthonous, not organic. And that therefore, what we really have is a continuation of an identity crisis that manifests itself in various challenges, including barriers to access to justice. Just to say that where there are any problematic examples in the spirit of African hospitality, I'll mainly concentrate them on the Ugandan jurisdiction, since it's easier to be forgiven by those at home than the visitors. So a lot of the case studies will be from home here, and I'll spare the visitors any pointed remarks. I will not belabor the point about access to justice. I had prepared something about Hobbes, Locke, Rousseau, Montesquieu, but that may be taking us very far. I talked about the social contract and the idea, really, also made by the President of the African Court on Human and People's Rights, about access to justice being broader than that fundamental right, insofar as it's linked to so many other issues. And I thought about those famous words by part of the human family. We hold these truths to be self-evident, that all men are created equal and endowed by their creator with certain inalienable rights, and among those are life, liberty, and the pursuit of happiness. And that to secure those liberties, governments are instituted among men. So the idea that governments are there to serve a particular purpose: life, liberty, the pursuit of happiness. But that we fear governmental power because that power can be abused, including, of course, executive, legislative, and judicial power. But that we trust judicial power because what judges have fundamentally, what they rest upon, is good sense. The so-called least dangerous branch that neither has the sword nor the purse, that must therefore rest for its efficacy and legitimacy and authority on its wisdom, so that we have less to fear from judges and a lot to gain from them. Of course, history has shown us that that assumption may have been false. But to say, therefore, that access to justice is linked directly to the achievement of all other rights, including the fundamental ones, life and liberty. But also to quickly say that if the names I rattled off appeared foreign, these ideas are not necessarily foreign. I pointed out in the longer paper the Manden Charter, for instance, going back to Mali, of some consensus puts it at 1236, definitely before this Bill of Rights of England of 1688, just a few years after the Magna Carta, predating the French declarations on the rights of man and citizen, predating the American Declaration, and containing within it similar expressions about justice, about human rights, including more things that are now called the third generation rights, but containing within it really a blueprint, a theory of justice. So that therefore, as Africans, we can claim a shared ownership of this provenance of these ideas. And if that was ever in doubt, we can also trace it in certain proverbs, such as maize cannot get justice in a chicken's court, or that in the bird's court, a cockroach never wins his case. And others, of course, such as tosala gwakawala gatonawulira gwakalenzi, that is Luganda for don't, basically hear the other side. So that a lot of these ideas are really reflected in, embedded in, part of an African philosophy, an African epistemology. So, if access to justice is a critical thing, has always been an important thing in Africa, how then do we achieve it? What is the East African context? I always think about the dictum of Justice Lugakingira in the Mtikila case of 1993. It's a long one, I won't go into it, but he really summarized three critical issues that made public interest litigation not just a good thing, but a necessary thing, a vital thing, perhaps even an indispensable thing in countries such as ours. Illiteracy, leading to ignorance of rights, poverty, apathy, and silence. To Judge Lugakingira, these factors created the conditions for public interest litigation. It was a question about locus, whether the Reverend Christopher Mtikila could bring the claim on behalf of other persons. And of course, the familiar questions about locus were being made, and this was the response, that in our society, when few people come, so if this one person comes, and the reasons I mentioned, if this person comes up, the courts should rise up and grant that person standing. A very, very important thing about how justice can be achieved. Nonetheless, reading it again, I thought about three aspects of it that give me some uneasiness in the dictum. Number one, the idea that these factors had emerged over independence, because we talked about the years since independence. In fact, of course, these factors had been created by the colonial experience. Because who was illiterate until you had to go to school to pursue a particular kind of knowledge, a particular kind of law, which law was denied, which legal education was denied to Africans until about 4 or 5 years before independence? So who creates illiteracy except that system of power that creates a divide, a disconnect between society and law, society and legal structures, society and the judiciary, society and the experience of how one engages with power. So the suggestion that these factors had emerged post-independence is ahistorical and problematic. Also, he envisages an able court, an ineffective court, because he talks about the courts granting this person standing. Of course, as some of the sessions will reflect, not all courts are always able in terms of resources and in terms of their own challenges to their independence and other challenges. So the idea of the court as this omnipotent entity is problematic. Thirdly, and I think most fundamentally, it seems to only envisage the court's role as waiting for the public interested person to come and then grant them standing when they emerge. Given the context that he had described, I'm not too sure that this is realistic for the reasons he mentioned. I sort of think of the biblical Matthew 7:7. Knock and the door shall be opened. But sometimes, and there are situations where we should seek the person who might have knocked because they didn't get to the door. Isn't there a possibility within a new jurisprudence of emancipation and dignity for a proactive court, a court that doesn't wait, a court that perhaps pursues, whether it's through judicial notice or through an epistolary jurisdiction, such as the Indian Supreme Court famously developed, receipt of letters and other proactive forms. Isn't it perhaps time that we don't think about a court that waits for the door to be knocked and envisage a court, because where is told that justice is blind. Should justice be blind? Or should judges see what is the context all around them, from which context, of course, they emerge? So, what is achieving access to justice in East Africa? What is access, for instance? I thought it might be possible to break it into a number of components, and I thought of maybe even up to 8 of them. And I partly draw from the work of the Committee on Economic, Social, and Cultural Rights in terms of the general comment on the right to food and general comment on the right to health. But I thought of some other elements. So, number one, and has been mentioned before in the morning, geography. Courts must be near the people they aim to serve. And for a long time, this has been a particular challenge of the East African Court of Justice. It's in Arusha, flights cost money and time. And so the fact that, very, very importantly, the court has seen it fit to establish registries in the member states is a very, very important development, as is the idea of sessions at the end of the year. Important developments. In this case, of course, following the model, perhaps, of the Permanent Court of Arbitration, which, although it's headquartered in The Hague, has regional offices in Buenos Aires, 2009, established one in Mauritius in 2010, in Singapore in 2017, and most recently Vienna in April 2022. So it seems that this is one element, geographical access, the ability to actually find the court nearby. The second, I think, is physical access. Yes, the court might be here in the commercial court, trade towers, and open technically, but are users able to access it physically? I think, for instance, of persons with disabilities, and I think in this particular case of my own classmate, Emmanuel Chandia, at the time the High Court had established an office in Naguru, which was inaccessible. He had clients to represent, but couldn't access the premises of the court. He filed a case challenging this matter in 2018. Judgment is still pending. Access to justice. Another fellow advocate, who was then a state attorney, Elisha Bafirawala, was at one point subjected to the indignity of having to be carried up to a court which was on a certain floor because there was no provision. The stairs were too steep. Think about it for a moment. The irony of a state attorney, a senior state attorney, representing the state, having challenges, reaching the courtroom to represent the state. There's the question again of economic access. So the court might be in Kampala or in the DRC or South Sudan. It might be accessible physically, but it might not be accessible financially. And again, I take note of in 2012, the ESCJ scrapping filing fees. But of course, challenges remain. It's still expensive. If you're going to fly to a particular place, and given some of the costs that have been awarded by the ESCJ and other domestic courts, some of these costs can be prohibitive, both direct and indirect. I think, for instance, of one particular taxing reference, number 1 of 2019, in which the fees taxed came to a total of about $140,000. Now, if this is Margaret Ziwa, yes, the citation is there. So if I'm advising a client and I say, look, in law they say costs follow the event, and the client asks for some of the costs that have followed the event, it seems that some clients may be minded to say, okay, if those are the costs that might follow, I'm not too sure that I want to. Of course, others have been a bit lower. I saw some of a range of $20,000. But in even costs of $20,000, using my salary, for instance, of Mackay University, that would take me about a year to pay the costs if I were the applicant, the petitioner. I might think twice. So what about another Ugandan or another citizen of the member states? The fourth is informational access. My lord, the 20 minutes we envisaged, I don't know if, maybe 10, if we could go back to the original, 30. Most obliged, my lord. This is just in the interest of justice. The fourth is informational access, and this relates to the extent to which the population is actually aware that there's a court in the neighborhood. The jurisdiction, and again has been mentioned in the morning, that not too many people know about the ESCJ, but even our national courts, it's not necessarily the case that courts, that the people are aware, for instance, about certain specialized divisions or particular about mandates and procedures, etc. So informational access. The fifth is language access, which needs no elaboration. The language of the court many times is English. Of course, there's questions of interpreters. There's one particular Nigerian friend who mentioned a court sitting in Igbo, 99% Igbo land in Nigeria. 99% of the court users understand the language, but the language of the court is English. So you have this farce where the court proceedings are in English and you have an interpreter, but everyone can tell when the interpreter is getting it wrong. Language access. The sixth is socio-cultural access. Yes, the court is there, assuming the fees are not too bad. It's about cultures. It's about the social norms and mores. One example is the case of an older woman who had been the victim of sexual assault. And given the system that we have, the evidence must be led and must go to each of the ingredients. When it came to one of the particular ingredients, all she could say, given the social norms, was that he made me his wife. Socially, everyone could understand what that meant. Legally, though, that the ingredient, the particular ingredient, one particular ingredient had not been established. Is there socio-cultural access to the courts in terms of the structure, in terms of language? I also think about religious access. There have been some cases in our constitutional court about, for instance, exams on certain days. One particular case in this regard, which is a progressive one, is Butime Tom versus Muhumza David and another, where the Court of Appeal made it clear, for instance, that you don't have to hold a Bible or a Quran. You can hold any other appropriate book in terms of Article 29. So that kind of accommodation, that kind of access in terms of social norms, religion, etc., very, very important. The seventh, psychological access. It's linked to but different from social culture. Because the number of times even lawyers are so intimidated, and again, this was mentioned in the morning, we hear of cases where lawyers, enrolled advocates, describe judicial officers as Your Majesty, Your Highness, not because they don't know that, but in the moment of fear and intimidation and being overcome, you then throw out a number of titles unknown to the law. I think about the approach taken in post-apartheid South Africa, for instance, where a deliberate effort was taken in the design of the Constitutional Court to ensure a design that sent a signal to court users that there was a break from the terror of apartheid. Light, for instance, in the courtroom, African art that allowed someone coming to the courtroom to feel at home, space showing the transparency around, artwork showing the rights in issue, faces of Mandela, the structure, the design, even of a courtroom. These things matter psychologically. Finally, even time access. How much time are you given to come to the court? And in most cases, 6 to 12 years are allowed in terms of land matters or civil. But it seems for the East African Court of Justice, 2 months. 2 months. It seems designed to actively impede access rather than facilitate it. What about justice? Up to this point, we have spoken about justice as if it were a question on which there's consensus. In fact, of course, it's contested. And again, it's linked to the disjuncture that appeared in the violence of colonialism. I think, for instance, of one case, Gwawo bin Kilimo versus Kisunda bin Ifuti. It's a famous case about where the court held that requiring an adult man to bear the liability, civil liability of an adult son was repugnant to natural justice and morality. Repugnant. But of course, our names, the very names of the litigants, Gwawo bin Kilimo versus Kisunda bin Ifuti, showed a society's understanding that you don't suddenly get detached from your family because you've reached the age of majority. In fact, you retain clear links to and responsibility, vice versa, a reflexive responsibility, that you're responsible for your father and your father is responsible for you. Now, so the justice, in quotation marks, delivered in that case was not really justice as the people of the time from Tanzania understood it. And in fact, this injustice has been proven in time by the terms of the African Charter, the Banjul Charter, Article 29.1 of which proclaims the duty of the individual, among other things, to preserve harmonious, but to respect one's parents at all times, and to maintain them in the case of need. So you see a disconnect between one kind of justice and another form of justice. There, therefore, seems to me to be a significant departure that we are dealing with right now, without addressing which we shall continue seeing the manifestations of what is really a deeper problem. And I therefore talk about the imperative of decolonization. I'll just mention 2, 3, or 4 cases that speak to this. Uganda versus Sabwe, for instance, where Judge Lugaizi abandoned the common law rule that said women, in case of sexual assault, where their evidence had to be corroborated because they were liars, they tended to lie. And he said, no, this was a relic of colonial times, it's not consistent with our values, and found it to be inconsistent with the Constitution. I think, for instance, of Mifumi versus Attorney General, where both the Constitutional Court and the Supreme Court rejected the very term bride price, saying it's not consistent with what was really happening, which is an exchange of gifts of appreciation, and thereby expunging the ghost, if I may use that term, of Amkeo. I think about also Traco versus Attorney General. Really, I think the quintessential case that shows us what is possible if we can excavate the dignity that has been lost in very many ways, including through the violence of law, where Judge Egonda Ntende, as he then was able to show that the idea that in the Government Proceedings Act you can't issue an eviction against government is based on an old law, a Crown Proceedings Act, which was based on the idea that judges are an extension of the executive. That was no longer the case, because now in Uganda, judicial power is derived from the people. That, I think, is some of the ways that we can go, and of course that reasoning was followed in the case of Kabandize versus KCCA, to abandon the rule about 45 days notice. And again in Charles Onyango Bo, where the offense of false news was again abandoned, based on that point. Now,
so we conclude?
As I conclude, I was just about to say the words, as I conclude. Let me say an interesting case. The case of Bunyoro Kitari Reparations Agency Limited versus Masindi District Land Board and 6 others, all of them district land boards, which was seeking to assert indigenous title in Bunyoro. And this is a very recent case about, the judgment was 4th February 2000, actually 2nd June 2022. In dismissing the claim, the judge said, any interest the indigenous peoples of Bunyoro could have had was extinguished by historical events in Uganda, the advent of colonialism, subsequent events, and he concluded by saying, the purported interests of the indigenous people of Bunyoro in the Sut lands passed into history, gone. The suggestion somehow, and the very last line he says, that the suit had been a tragic one with no sense of direction. This is a suggestion of that somehow the rights that you had are gone because of the fact of the colonial disjuncture. It's very interesting when you think about, for instance, the decision in, I'm just 2 pages away from finishing, the decision in Mabo, number 2, versus Queensland, an Australian case from 1992, where the High Court of Australia was able to find indigenous title relating to events going back to first contact in 1877. Those rights had not passed into history. They were not described as being a tragic one with no sense of direction. Rather, the court was able to excavate, rehabilitate the dignity of the people, the first peoples. So, and more recently, the very last case I cited before concluding, the recent case from the Kenyan jurisdiction, the name is a bit long, Zerabanu Jan Mohammed suing as the executrix of the estate of His Excellency Daniel Arap Moi versus David Chelugui. The decision came out 22nd July 2022. A very interesting one insofar as the court was able to find that the Constitution of Kenya could apply retrospectively to 1983 when the taking by Moi happened. So it had, the injustice had not passed into history. It could be cured because of the fundamental nature of the value, the constitutional value at stake. That's the way to do it. It can be done. In conclusion, I think the task at hand to achieve real social cultural justice requires a deliberate epistemology and jurisprudence of emancipation and liberation and restoration, what Naudere has really spent some time talking about. If we don't do that, I'll end with what normally happens in the so-called plea bargaining sessions. You have a group of tired, bewildered inmates who are brought before a judge, an equally tired judge who has to deal with case backlog. Having been previously intimidated by the warders, they say, look, you know you have spent so much time on remand. Why don't you just go and admit? If you admit, if you confess to the crime, you might get the time spent on remand. And that's normally what happens. Those who admit, confess, get convicted and get time spent. Those who claim innocence go back into the legal void, no man's land, until who knows when. It has eerie recollections of Ara versus Okello, where the person was told, confess, confess, and your punishment will be small, and we shall not take you to the Bwana. It seems now that you have a judicial system crowded around based on the intimidation of people who have no idea what to do, who have just given up. The very last line, my Lord. It seems that the work to be done is massive. It includes the reconsideration of so many things that we take for granted. A rule of sub judice, for instance. The idea that somehow citizens in Uganda should not talk about what's happening in their courts. But I thought under Article 126, judicial power is derived from the people. So how does a rule of common law, a rule of practice, become more fundamental than the new idea under the Constitution? The idea of imprisonment for debt. How do we allow courts to become private actors for private individuals? And I could go into the question of the Witchcraft Act, which one act that criminalizes only one traditional religion. You can imagine, notwithstanding Article 29, but I have tested your patience and I really appreciate your patience thus far, and I'll stop here. Thank you very much.
Thank you. Thank you, Dr. Kabumba. You'll agree with me that if you had had all the time, we would have left this place with a PhD thesis. But we lack the time. I'm going to open the session to Q&A. I don't know how many will manage to capture, but kindly put your hand up and say your name so we all know who is saying what. 1, 2. Aha. The Court of East Africa wants to ask. Yes. Yes. That thing you press, little thing in the middle there, is touch. It won't do it? You see the one which is zigzag there? Touch it, just touch it. Line is off.
Can the person with the microphone please bring it?
Oh, dear me. Can you pass this one on? Oh, dear, dear, dear. All right, while we are waiting, I could use this time to say something. When you look at the topic, It says shaping East Africa for access to justice. That could be tackled at two levels, and Dr. Kabumba has tried to do that one. One, at the regional level. How do we shape the regional level of things to make access easier? Probably that means most importantly, most immediately, the court itself, the ESCJ, and others of that kind. But there's another level, which is the national. I just came back from Sudan. My Lord Chief Justice, welcome from Sudan, South Sudan. And there they're grappling with a review of their judicial system. And you find immediately that there are enormous opportunities and challenges. South Sudan has gone through any number of judicial systems: Egyptian, Sudanese, Arabic, Sharia, African, common law. They've been through it all. And their language for the judicial people, the legal people, is Arabic and English. Cases are heard and judged in Arabic, right from the lowest unit to the Supreme Court. Now we have in the East African Court a provision that says the national courts, once they are confronted with a treaty issue, East African treaty issue, you have to translate that, interpret it, and so on. Let the court, national court, deal with that one, and then maybe bring it to the, if it's interpretation, bring it to Arusha. But if the judgment is in Arabic, right from beginning and all through the appeals, and in all those systems, Sharia and the common law and civil law and Egyptian, how do you reshape that to bring access easier for the litigants, for the court, and for everybody else? So the national level is going to be extremely important, just as the regional level is going to be equally important. My Lord, you now have
Thank you very much,
access to asking questions.
Thank you, my Lord, and thank you, Dr. Kabumba. My question is about the issue of the court, and I'm specifically thinking about, sorry, my name is Charles Nyechai. I am with the East African Court of Justice, First Instance Division. So I'm thinking more about the East African Court of Justice as I ask the question relating to the issue of the court awarding costs. I understood you to see that as possibly an impediment to access to justice. What I didn't hear, and it's perhaps understandable because His Lordship, who is chairing, was exerting pressure for you to finish quickly, is I wanted to understand what is it that you're proposing on that. Is it that you are opposed to the very principle that is stated in our rules, for example, that fundamentally costs follow the event, and then gives the court a discretion? I ask this because I think since I joined the court, in every single judgment or ruling that we deliberate about, that question always arises. With respect, I'm not sure that the Margaret Ziwa case was the best example, because there, the costs were being awarded against the community, the East African community. I think the point you are making relates more to East African citizens who are seeking to approach the court. So I just want to hear, are you opposed to the basic principle, and or what is it you would suggest that would address that in the context of access to justice? Thank you very much.
Number 2, then you be number 3 here. Then Dr. Kabumba can deal with those 3. We have a mic there.
Thank you very much, moderator. And I want to, first of all, thank the...
Kindly give us a name, please.
John Bosco Karisa. I'm the CEO of East African Business Council. And I want to thank, first of all, the president of the court for organizing this engagement and inviting the civil society and the private sector. And I think this comes back to the question or the challenges raised by the good professor in terms of accessibility of the court. To be honest to you, I understood the good work done by the court. Just last month when we were in the RC, and all the judges are my neighbor in Arusha. But I understood that the court, and that is my question, is confined to serve politicians as opposed to serve the society. So my question is around the constituency. What is the constituency under the scope of the court? And this relates to the question that Honorable Minister in charge of ESC was raising. And it confuses me. It is a paradox in terms of the national court vis-a-vis the ECJ, the supremacy, the primacy of the ECJ over the national courts. Because we realize that there is a conflict between the East African court vis-a-vis the national courts, who has the mandate to serve whom. And that has jeopardized the coverage of the court. As I mentioned, to be honest and to be fair, it is just recently I understood that the East African Court of Justice has an extended mandate to cover trade and investment related issues. Otherwise, I thought is to serve the interests, to serve the captains, the architecture, but not to serve the people and the citizen and the private sector. But when I looked at the article in the treaty that established the court, I realized that the court has a mandate to serve the people and also to serve the private sector. So I want to really get from the doctor in terms of constituency before we talk about accessibility in terms of language. Those will be there, those can be solved, and there is an effort. But we want to understand the constituency and the coverage of the court and its mandate and the limitation where do you draw the line between national courts and the regional courts so that you don't bring conflicts. And I was looking at a good example of European Union court. In 1950s, every year they were handling, 1950 when it was established, they were handling only 10 cases. But now, annually, they are handling 400 cases. And more cases are generated by the citizen, are generated by the private sector. And that brings the reach in terms of the services of the court. Court being close to the people. Court serving the people. Court addressing cross-border conflicts, issues that are impeding our growth of intra-regional trade. So let's get it clear. Let's eliminate those nuances. And let's make it clear and inform our citizens very well the law of East African court. Otherwise, it will continue to be muted. We just, and I want to appreciate the current president who has enabled the private sector, civil society to come, and who has brought innovation to this court. You can see him, he's bringing closer to the other organs of the community. Otherwise, it was detached completely from the other organ of the community. Thank you very much, moderator.
Thank you. Thank you. Clash between the court at Arusha and the courts in the nations. I don't know how Dr. Kabumba would deal with that one. But when I used to be there, it was slightly different. and I believe it's still the same. There's a good demarcation. Arusha is talking about the treaty. Jurisdiction is based in the treaty. Interpret the treaty, apply it, and so on. If anything in the nations has anything to do with the interpretation of the treaty, we are okay. If it's beyond that, there's where the line would be. But Dr. Kabumba will deal with that one. Number 3.
All right, thank you very much, Dr. Kabumba, for the good presentation. My name is Jackie Kamau from Kenya, judge in the High Court. I just wanted to make a comment because you were very surprised that there's a case which has been pending since 2018, so there's lack of access to justice. So mine is just a comment, just to say that in Kenya we are currently very few judges. We are like 62 and expecting maybe about 200 to be appointed if we are to go to with the constitution. So with the 62 judges serving a population of about 50 million Kenyans, 4 years might not be too bad. Depending on the number of cases that are filed, there has been an increase in the cases that have been filed. But we are trying very much, and cases which are over 1 year are now known as backlog. So we are trying to push as much as possible. So we hope that maybe we will need to check on the facts of that case to find out whether it has still not been delivered. I'm not holding brief for anybody, but just to disabuse anybody who might think that we are not working. Thank you very much.
You've been number 4, 5, 6, 7. Oh my goodness, 8, 9, 10. Do we have the time for that? But for now, let's answer the first 3. Then 4, 5, 6, 7, we'll see how far we can go with those.
Thank you, my lord. My name is Robert Eno. I'm the registrar of the African Court.
No. I wanted him to answer the first 3. Then you'll come later in the second phase. Thank you.
Okay. Thank you, my lord. To Judge Ochaya from the ESCJ, thank you for that. The costs, yes, I understand costs follow the event, but the suggestion I just made was that the event should not be expensive. So if the event is not expensive, if the courts are closer, if for instance, the ESCJ had a permanent regional branch with sessions going on, and the costs were, so a lawyer would not then bill you for flights to Arusha, accommodation, and the complexity of this case because it involves ESC law, because there are many practitioners. So if the cost of the event can be reduced, then you can have costs that follow the event that are moderate and that perhaps may be acceptable. It really goes to the question of direct versus indirect legal obligations, economic, and it goes more to the indirect one. That goes to the point about Honorable Margaret Zio had won the case, got the costs, but if I'm advising a client, I'm duty bound to tell them about what could happen. And if I tell them, look, the worst that could happen is that there has ever been costs in the amount of 140,000 USD, some of them being instruction fees. It will be my duty to tell the client about this, and I suspect some clients may take a step back as to whether they really want to engage in an arena where that could happen. Mr. John Bosco Kalisa, the question about, it's about jurisdiction, and it's a difficult question. The EU case that you mentioned, there was, for a long time, the EU talked about direct applicability. In the cases of Costa versus NL had made the point of direct applicability, and they had really grown to the point where they had the political will to back up that legal position. But of course, even legally, that became problematic when the German, I think, to my mind, the German Constitutional Court first challenged that idea and said, where fundamental constitutional German values are implicated, we might review ECJ decisions or even EU law because of implications they may have for basic rights in the German legal order. So even in that jurisdiction, you had those challenges and tensions. The UK also, of course, famously, the tensions about even questions about fishing that have resulted in the famous Brexit and the revolving chairs we now see about prime ministers. So the questions about jurisdiction, I think, are going to arise. As my lord has said, they will arise particularly, I think, at that point when you have an ESCJ decision that has a bearing on certain accrued rights in a member state. And there you may have a pushback, for instance, from the Constitutional Court or High Court that might set up the position for a conflict of laws. That's my fear. But just on that same point, I think we always must live in the shadow of 1977, number one, what led to the collapse. But secondly, and I think I felt I had some bit of something about the court and the political organs even today. And that it goes to the Katabazi case, of course, and the question about mandate. And I suspect that another shadow that hangs over the ESCJ is the Mike Campbell case. What happened to SADC when they asserted the rights of the individual, but then the summit then said, not only did they not uphold the decision, but they just disbanded the court. So there's that fear also. And so to go to your question as to whose court is it, unfortunately, my answer must be that at the moment, it is not yet a court for the citizens of East Africa. It is a court for the heads of state, for the government, and that's just my opinion. And I think the task now is, again, to deepen and to make it really a court that can assert, and of course the court has taken steps, Katabazi case and others, but I think there's that reality. It may be a political reality, but I think there's that challenge. The one from Judge Jackie, I really take the point, and there's something amazing about the jurisprudence from Kenya. I'll not go too far into that, but there's something that's being done right in Kenya. The case was the Ugandan one, where 2018 is actually very recent. If you have a 2018 matter cause listed, I was in the Constitutional Court last week, and a lot of the matters 2017, 2018. So it's our problem that we need to work on. Thank you.
We have, I think we can press 10 more minutes. Let me ask you to ask a question, yes. Every one of you. Don't make a preamble.
I will not. Thank you, Chair. My name is Robert Eno. I'm the Registrar of the African Court. I just wish to share two experiences from the African Court with respect to the issue of cost and the challenge of language access, and to ask Dr. Kabumba whether we are doing it correctly based on the challenges that you've posed. First, let me thank you for the very clear and eloquent presentation. With respect to cost, the general rule of the African Court is that each party shall bear its own cost. If you look at almost all the judgments of the African Court, the court ends by that statement, and it is in our rules, that each party shall bear its own cost. It is the general rule. The exception, and we've not even applied that exception, is to apportion cost to one of the parties, usually the party that has lost the case. So I would like you to maybe speak to that, whether it is a proper approach which will encourage access to the court as per your presentation.
Thank you.
The second one is on language.
I'll allow you only one.
Yes, the second
there
one
there are 8 other people coming.
Yeah, the second one is on...
No. Let's go with just that one.
Okay.
Let's allow the others to ask another. Be very brief, please. Number 5.
Thank you, Your Lordship. Thank you very much, BK, for that brilliant presentation, which should surprise no one because we kind of know you. But I have this lingering thought that you see something that is seriously defective and which should be set right. But you're not saying exactly what we should do. You're saying it's a contradiction of so many things, a confluence of so many shall I put it, things that are incongruent, incongruences at every level, where you have law and justice systems that are not autochthonous, they are not, how did you put it? They are not organic. They were grafted onto our societies, all over Africa, let me say this. It is all over Africa, not only in East Africa, but everywhere in Africa. Laws that came from England through India and then to our continent. Now we have, as my lord, the judge was just telling us, that in South Sudan, who fought so assiduously to liberate themselves from the imperialism of the Arab North, are now being handed down judgments that are written in Arabic. It's a mess. Now, are you proposing a revolution? Because I'd follow you. Are you proposing a revolution, and should that revolution take as a form? What shall we do? Because it is true that it's not possible to erect a system of justice delivery that is not geared towards the real needs of your people, because they will not understand it, the language is not theirs,
Thank you.
the concepts are not theirs.
Thank you. So the question is evolution or revolution? Thank you. Number 6, I believe. Who was number 6? Was it you or there? Here. Bring the mic here. Do you have a mic there? Thank you. Make it very brief.
Yes, I will be brief, my lord.
Yes,
If
yes.
you permit, I can even address my comment being said. You can roll on it. Fine. Mine is first a clarification on interest, the principle that cost follow the event.
Why is cost such a big thing? Judge, you started it all. Why is everybody about cost? Justice is not cheap.
No, that is a little thing.
Anyway, go on.
In most of cases, if you look at the jurisdiction, the jurisdiction of the court, you shall see that whenever there is a litigation which in nature involves public interest, there is no award of cost. With that, I go back to the jurisdiction of the court. First, we shall take that under international law, the obligations that a partner state can have, or a jurisdiction of a particular international court can have, is by way of what has been granted by the Constitutive Act. It cannot be created by judges as a matter of principle. And then you shall see that the judges shall interpret those provisions in accordance with the aim and the purpose of that particular act, in accordance with the Vienna Convention on the law of treaties and the act itself, which constitute the legal source of that particular court. Here, I mentioned that access to court is a principle which is very important for anyone who wants to have recourse to court. But judges have to take into account the limitations which are enshrined in the Constitutive Act. I take an example of International Court of Justice, for example, it is interstate court. Individuals have no access to court. I take an example of European Court of Justice. There is a clause in the Article 23 that direct individual dispute are the one to be litigated before that. Here, the attention that I want to put for those who are applying laws or international law is just to be abided by the principles of international law and then try to interpret the Constitutive Act in a way that allow access to justice, taking into account, of course, those obligations under international law.
Thank you.
I assume, I finish, I assume that if a judge has not careful enough and does not look at those particular limitations that are set in the Constitutive Act, it may even raise the amount of costs, whereas the end of that will be that a declaration that court has no jurisdiction. This is just to say that let us work as an international judges, taking into account all those principles of international law. Thank you.
Thank you, Vice President of the Court Emeritus.
Yes, my name is Nkurunziza Riboa. I'm the former Vice President of EACJ.
Thank you. Number, oh boy.
My Lord, I was number 7.
1, 2, 3, and we stop. Very brief.
Thank you, my Lord, and thank you, Professor. I'm always glad to listen to Professor. My name is Feston Senga. I'm the Deputy Registrar, Criminal Division of the High Court of Uganda. I would like to pick Professor's mind further on plea bargain. You criticized it, and you've always criticized it, but we believe this is one of the avenues of quick access to justice for people in prisons, especially because it cuts out the element of time and resources required to go through a full trial. Yes, we know the challenges associated with it, like the one you've pointed out, which we try to address through sensitization, holding sensitization camps in prisons. But I want to pick your mind further. Do you think it's not a useful tool, or is your view that it needs improvement? Thank you so much.
Thank you. Plea bargaining obviously will be a lot more into the criminal area, which is okay, because as I said before, we are talking about the regional, which is mostly treaty, but we are also talking of the national. So some of those things can be woven into there. Maybe you'll answer that one as well. But let's take one more, and the last one, and then we call it a day.
Good afternoon, Judge. My name is Ogada. I'm a student and a teacher of international law. I will be very brief. Now, any court has two approaches to law, which is expositorial or censorial. Expositorial, dealing with the law as it is. Censorial, the morality, looking at law from a moral perspective. Those two approaches vis-a-vis the East African Court of Justice means that in the first sense, the court can only limit itself to the treaty and what was intended with the treaty. Our Achilles heel as a region is that even in terms of interpretation of the EAC treaty, the court does not have the benefit of the travaux préparatoires, the working documents that generated the treaty. That's a problem, because if you were to remain fiddle to interpretation using Article 31 and Article 32 of the Vienna Convention in terms of interpreting the treaty, the question is how has the EAC treaty been interpreted so far? Secondly, the censorial mode, human rights, rule of law, and the politicians are here. We need urgently protocols on human rights and treaties, protocols dealing with the rule of law. Otherwise, the judges will be handicapped. An international judge cannot deal with treaty issues like they will deal with in municipal context. Thank you.
Thank you very much, Professor. The last one on this end.
Thank you, my lord. Dr. Kabumba, my name is Okubo Ifnalis. I'm the immediate past registrar of the courts. Now, you talked about access to justice being broader than traditionally the way we know it. Looking at the jurisprudence of the East African Court of Justice, do you foresee East Africans taking on their partner states on socio-economic rights? We are talking about the rights to housing, the rights to education, dignity, health services, clean water, environment, socio-economic rights. And remember, Article 6 and 7.2, one of the principles there is social justice. Do you foresee that? I'll not comment about cost because all those you're talking about are my decisions. Thank you.
Thank you very much. Save us the costs. Dr. Kabumba, quite a plateful there. I'll also limit you as to how long you take to answer them.
Thank you, my lord. Thank you, colleagues. Robert Eno, the question of costs in terms of the African court, of course, there's a distinction between a court that's supposed to do public interest, sort of almost by its very nature, although it has handled certain interstate matters like DRC versus Uganda. Ideally, it's a public interest court, so it makes sense for each party to bear their own costs. I'm not too sure that Mr. John Kalisa would be very happy to take a case to the ESCJ and not get some costs. So I'm not really opposed to the idea of reasonable costs following an event that is reasonably priced because of physical access. But it's just the idea that it should not be prohibitive, and perhaps that's the spirit. Mwalimu generally, the question about what it is that I'm proposing, I don't think I can be a revolutionary in a tie, so it may be more of evolution. But even the small things matter. As we speak, I think 2 days ago, the Malawi court is considering whether to drop the question of attires, the judicial attires, the robes. And I think it's an important conversation. I think it took place in Kenya under Chief Justice Willie Mutunga. After he left, I think the judges decided they liked their robes. But it starts from the simple things, how the psychological access, I think. So from there, the more creative or more innovative approaches in terms of challenging orthodoxy can then take place. Monsieur Edouard, the former vice president, I take the point about the obligations, the duties under international law. But even there's scope. And I think I'm sort of attracted by the work of Marty Koskenimi, The Politics of International Law, and Judge Rosalind Higgins, her book, Problems and Processes, that make the point that it's not really clear-cut that you're sort of tied down to the text. Even in international law, there are ways around, there's scope for innovation. I'll give 2 examples. The Southwest Africa cases that ended in disaster in 1966. Namibia, so the idea of what the blacks were suffering in what was then Southwest Africa. Now, there was, and of course, the strict positivist approach was an individual. You cannot have a public interest action under the ICJ terms. Now, that ruling was disastrous for the legitimacy of the ICJ and resulted in a sense, the international community bringing back that same case under the Namibia opinion. So they had the same facts come back before the ICJ under the guise of a request for an advisory opinion, and in the end, some kind of justice was done. The second, a similar thing happened in the nuclear weapons advisory opinion, where again Israel protested vehemently because it could see that some of the so-called, some of the things in the advisory opinion were really contentious. In other words, it may not be a very neat solution, but it's just to say that the hands of judges are not tied, whether under national law or under international law. There are ways out, and those ways should be adopted. I think, Festo, Your Worship, Festo, the plea bargain, first of all, you promoted me. Professor is the title I like to have, not yet. But the idea of plea bargaining, I think, has a taint, I think, of duress. Or undue influence, that you're talking to someone who has lost their liberty. They're not really a free person. So if the prison warder or any other person authority comes and says, oh, we're having a plea bargaining session for 2 weeks. If you miss the boat, I mean, you'll come back to this hall, this hell hole that is prison. We have prisons that are overcrowded. So, and this goes back to Generali's question. If you want a radical answer from me, I would suggest either community service orders may be the way to go, or we discuss this thing called prisons. Because if you were to excavate, you'd find that very few societies in Africa ever had a place, a room, where you put human beings and lock the key. It's not African. Community service orders, reconciliation, and other restorative approaches would be, and so if you don't have overcrowded prisons, then questions about plea bargaining may not arise. Ogada, I think it goes to the same point that the former vice president made, that yes, there might be strictures in terms of what treaties provide, but there are ways around interpretation, and I think a very good example, again, is provided by what the court did in the Katawazi case. To use rule of law provisions to assert an implied human rights competence. Evidently, it has been accepted by the political factors because, I mean, Anyang' Nyong'o was a backlash, but there has not really been serious backlash from Katawazi, which seems to imply that there's some kind of acceptance of that position. There may not be a protocol on human rights yet, but I think the scope, even within the technical rules of the interpretation under either customary law rules or even treaty, the VCLT, there's room to do the right thing under the law. Finally, Judge Alex, the past registrar of the court, whether East Africans will take on the question about socio-economic rights, I hope they do. There are some cases, this is now sub judice. I know in this session there will be a case by the Center for Adequate Rights, CEFROT, on this question, on questions of such nature. There have been questions before, I think, by Adrian Juko and the Human Rights Awareness Promotion Forum about the right to health with varying degrees of success. I think, if I'm looking into the crystal ball, I think there's scope to do that, although I don't think they may be as successful as given that you can only stretch rule of law so far. But to the extent that it's possible, then I hope that the court will do the right thing. Thank you very much for your kind attention.
Thank you, Dr. Kabumba. Thank you, all those who contributed. And thank you, all those who listened. It's a massive job to reshape East Africa to access justice. First and foremost, it's just one tool of deepening, widening integration. There are other tools that are used, the political, the social, the economic, investment, trade, banking, name them. But ours is one such tool. There is obviously need to do something about the whole thing. We didn't have time to go into everything, but to me, 2 or 3 other things stand out. There's something in the treaty about right of establishment, meaning professionals should be allowed to go anywhere in the geography of the area, set themselves up, and give a service. We start with the lawyers. Let them go to South Sudan, Malakal, far out there. Let them go to Mogadishu when they become a member. Let them go everywhere. Those who are already familiar with the East African Court and its jurisprudence. Let them be available in those areas. Because if they're not, then access to justice is curtailed. Number 2, let's intensify. We have sung this song many, many, many years now. And I don't know how we should intensify it. Let's intensify the opportunity we have for national courts to hear at source, wherever they are, hear issues about the treaty, its interpretation, its application, and so on. That will help bring justice to the nations, and it will help people from moving all the way to Arusha, whether virtually or whatever. Let's intensify that tool. Number 3, the ESCJ is not quite East African Court of Appeal, it's not. But when we had East African Court of Appeal here, those of you who were here, you remember that this work was almost entirely by circuiting. They would go to Mombasa, they would go to Nairobi, they would go to Tanga, they would come to Entebbe, Kampala, they would go to Nairobi, everywhere, circuiting. And that one is gaining traction because even with the national courts, in Sudan, in Uganda, in Kenya, and in Tanzania, we now have even the Court of Appeal circuiting. Supreme Court, I believe in Sudan, they're beginning to do that. They go to the people. Money, of course, is a problem, especially for the East African Court. We have to have the budget to allow that. But otherwise, it would be a wonderful tool to bring justice and access closer to the people. In a nutshell, therefore, let's do everything we can to reshape, to retool, to realign, to repackage the geography of East Africa, the law of East Africa, the jurisprudence of our courts, the tools that we use, the courts that we have. Let's do everything within our power. And if we do, then we'll have reshaped access to justice and thereby intensified and widened the integration effort. Thank you very, very much. Clap for yourselves. Clap for the presenter, Dr. Kabumba. And if you wish, clap for me as well.
Thank you very much, retired Justice Ogola, and the panelists, Dr. Kabumba. You have done great justice to the keynote and have set a great foundation for the discussions that we are going to have for the days ahead. When I heard the applause, I thought it was not deserving. Can we please give a bigger applause? Thank you very much. So going forward, just a few housekeeping updates. We have emergency medical services on this ground. So for anyone who would be interested or who will need the medical services, right on this floor, when you get out to your right, there's a room for that. Like I mentioned at the beginning, we expect the President to close this conference. And because of that, we are all expected to take our COVID tests tomorrow morning. It's now time for lunch. It's been a long wait, and thank you very much for being patient with us. Well done. So there are 2 stations for our lunch. We have the Choga Hall, and each of you is going to receive a coupon that indicates where you'll go for your lunch. So we have the Choga Hall, and we have the Kazinga Hall. With that, I would like to say, or just before that, I just want to give one last piece of information. And this is on the upcoming panel, which is titled Modernization of Courts, Shared Experiences on the Digitization of Courts. Kindly presenter, moderator, and the panelists on this, for this session, prepare yourselves, and we shall have that session right after our lunch. We'll be coming back here at exactly 3 p.m. Please try to keep time so that we can finish our business of the day. With that, I'd like to say bon appetit. Enjoy your lunch.
But not that one, no way. Oh, really? You have a better one. No, being a professor is getting better. they're like they're always moving from one presenter attention to another.
The Republic of Uganda. The overall objective of the conference is to stimulate high-level conversations and discussions on emerging legal and judicial issues.
A keynote address on shaping East Africa through advancing access to justice shall be delivered by Dr. Businje Kabumba and shall form the basis of the panel discussion of the Chief Justices from the EAC partner states.
During the conference, a number of topics will be discussed on issues touching the efficiency and effectiveness of the court, its jurisprudence, challenges, and the best judicial practices, among others. Following the conclusion of the conference, the East African Court of Justice shall hold its annual rotational court sessions during the month of November at the Commercial Court of Uganda premises in Kampala, Uganda.
The second annual East African Court of Justice Judicial Conference is expected to draw participants from the East African community, who shall include Chief Justices, Ministers of Justice, Attorneys General, Ministers in charge of East African Community Affairs, judges from the regional and the national courts, the heads of EAC organs and institutions, members of parliament, legal practitioners, members of the academia, representatives of civil society organizations, and representatives of the private sector. We also expect participants from the African Court on Human and People's Rights, as well as participants from the ECOWAS Court and the COMESA Court.
We welcome you all to our second annual East African Court of Justice Judicial Conference.
The East African Court of Justice, contributing to regional integration by ensuring adherence to justice, rule of law, and fundamental rights and freedoms.
Every waking day is a reminder just how beautiful this, our land, truly is. The kind of beauty that you can only find here. In the lush green all around us and the wondrous sights within. It's what you feel in the gentle caress of tropical wind from the mountaintops. And the glow in your heart from a warm neighborly invite. It's in the distinct aroma of our cooking, to the taste of food that takes you on a journey. In the sound of homecoming and the sound of Mother Earth. In the magnificence we find on our travels and the exciting moments we experience. Ours is the kind of beauty that comes in all things big and small. All we have to do is awaken our senses and truly enjoy what's uniquely ours. Explore Uganda, the pearl of Africa.
afternoon. Check, 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 check. Good afternoon. Electronic court management systems that have been provided by Synergy. David is the person who actually makes the initial contacts with the different judiciaries to ensure that we are able to buy into the proposal and eventually have these electronic systems in place. Mr. David has a BA in International Relations from Yerevan State University of Armenia and is also
as head of subject and assistant head of subject at LDC. He's advocate of courts of judicature in Uganda, senior partner at MS Muchibi and Keyune Advocates, a commissioner for oaths, notary public, and an associate chartered institute arbitrator. He holds masters in international trade policy and law, masters in business administration, master of laws, masters in construction law and contract management, postgraduate diploma in legal practice, and bachelor of laws. Mr. Muchibi has published in international and national peer-reviewed journals. He has published with the JACL of the University of Western Cape, among others, and he has also contributed to the authorship of the Judicial Handbook on HIV and the law in Uganda, and Toolkit for Legal Professionals on HIV-related legal services. Our presenter is the secretary of the editorial board with Uganda Law Reports, editorial member, board member of the Uganda Living Law Journal of the Uganda Law Reform Commission, the Uganda Law Society Law Journal, Uganda Network on Law, Ethics and Human Rights. He has trained different justice and legal service providers in public, private, and NGOs nationally. This includes judicial officers, members of parliament, Office of Directorate of Public Prosecutions, among others. Mr. Muchibi is also a Cisco certified network associate. So let me also introduce you to our panelists here, who, after the presentation by Mr. Muchibi, I'll ask a few questions to reflect on some of the things that happened during the modernization and digitalization of courts and share their lessons learned and some of the challenges that happen in these processes. With us, we have Honorable Justice Jeffrey Kirabvire from Uganda, Justice of Appeal with the Judiciary of Uganda, Chairman of the IT Committee of the Judiciary of Uganda, former Vice President of East African Court of Justice, and former Chair of IT Committee of the East African Court of Justice. We also have with us Honorable Lady Justice Jackie Kamau, presiding judge at High Court Kisumu in Kenya. Justice Kamau is chartered arbitrator with Chartered Institute of Arbitrators of Kenya and the UK, former president of Kenya Magistrates and Judges Association, former member of Integrated Court Management System Committee at the Judiciary of Kenya, and currently the chair of the East African Magistrates and Judges Association Subcommittee on Gender. The last panelist that we have with us is Honorable Justice Harrison Mutabazi, Judge of the High Court of Rwanda, spokesperson of the Judiciary, Inspector of the Courts, and Secretary General of the East African Magistrates and Judges Association. Thank you, honorable panelists, for being with us. Now I will hand the floor to Mr. Muchibi for his presentation. I'll ask him to give us a presentation within maybe 20-25 minutes, after which we will pass to the next phase of our panel discussion, to the questions to panelists. Thank you, please.
Thank you, David, for that introduction. Honorable Justices of the East African Court of Justice, Honorable Justices of the National Courts within the East African community, colleagues, members of present and all protocol observed. Allow me also to welcome you to this session and this particular session. Afternoon sessions are not always very friendly, but when it comes to digitization, we are going to be very lively. And you shouldn't have any doubt about that. I'll request the systems manager. My presentation is going to be projected. I have a PowerPoint, and I'll be highlighting the key important areas so that we save time and go to the panel discussion. I welcome all of you to this session, and I've presented similar sessions in other forums, like the recently Uganda Law Society annual general meeting. We are also having a discussion on digitization together with His Worship Jamson Kareman, trying to see how we move there. I'm very lucky that the same has happened to the East African Court of Justice, and as we are going to see, the RECs, the regional communities have gone a bit far with the modernization of courts. This is something challenging locally, but with the time we shall have to adopt it and move forward with it. So we are going to look at the shared experiences on digitization of courts. And the concern is modernization. By digitizing, are we modernizing? Some people are having issues with digitization. Others have complained that digitization is a form of denial of access to justice for those who cannot manage the system. And we want to keep it simple. It is not going to be too technical. We are not going to go into the nitty-gritties of IT, which David handles well. We want to make it friendly to the lawyers, judicial officers, and our clerical staff. The breakdown is as follows. I'll just highlight a few things, but the major concentration will be on the concept of digitization itself and the digitization, how it has been handled in the African regional and sub-regional judicial institutions. It is not something I was telling the lawyers in Uganda. They thought it has started with Uganda. It is something odd. It is not new. So equally, we shall embrace it here. It has been in several African regional and sub-regional, even outside Africa. Then we shall look at also specifically the sub-region of the East African community. Then how do we adopt ICT into court processes? Then what are the perspectives or prospects of digitization, the challenges? Then we can highlight the way forward. How best do we move with this system? So briefly, I don't want to go too much into the history, but we all know where the East African Court of Justice has come from. That is basically a brief background, but specifically, digitization as a program has been embraced by our national courts, equally the East African Court of Justice. It is not only the judiciary doing this, it has been embraced by even government in other institutions. In Uganda, for instance, our NDP3 talks about so much integration of ICT into service delivery. So this is something we cannot avoid, whether we like or not. And we shall see how we can benefit from it. It has been given different names in different jurisdictions. For instance, Kenya has it as ECMIS, which is not, that is electronic court management system. In Uganda, we still have ECMIS, but with a double C, which is the electronic court case management information system. Other countries like Rwanda have it as IEMS, which is still to do with electronic management system. That is IECMS. So it has been given different names, but whichever the nomenclature, the purpose and the theme is the same. So it is important for us to know that the digitization process has not started with the ESCJ or with our national courts. It has been all over in other regional umbrellas. If I can take you, so far there are about 5 RECs that have adopted digitization. We have the ECOWAS Court of Justice, we have the COMESA Court of Justice, then we also have the SADC Tribunal, as well as now the East African Court of Justice. We shall all agree today, after COVID-19, and now Ebola in Uganda, there's nothing you can do about digitization. You cannot avoid it. almost COVID-19 closed course business. We are all closed and we could not function. So the only way we function is to try to embrace the electronic system. And we don't want to move backwards to that kind of situation. We just have to move ahead because the pandemics, we have no control over them. As we talk in Uganda, some districts are under lockdown, and they also have courts. Courts have to continue and operate. So this is something we have to all embrace and appreciate. Honorable Justice Chiawire, one of the panelists, has written about how the East African Court of Justice embraced digitization past COVID-19. And the discussion is very clear therein, and it embraces some of the key aspects we can get out of this digitization. There are so many attributes of digitization. Efficiency of judicial procedures. We are talking about filing. It doesn't make any more sense for me to carry heaps of papers, files, and run to court. Recently in Kenya, we saw the presidential election petition where people were carrying huge of files in a lorry to Gandhi file. We need to move away from that kind of a system. Why should we pile a courtroom with heaps and heaps of what? Paper. This is something simple. We can easily scan. We can even not scan. We can just file electronically, and the case is done what? Registered. So there are so many attributes we can see in this kind of system. Increase the level of transparency. We have been having challenges where people are complaining that some file cases and they determine which judge to hear. They influence the allocation of a what? A file. With the electronic system, we can easily avoid that kind of system because everything is digitized and is run electronically. It puts away sometimes there's so many physical hands in case management. Then improvement of the level of information security, whereby national, of course, laws have to embrace this, like we need to look at issues to do with that. Data protection, I'm sure most of the regional courts, the national courts within the ESC have laws on data protection. Okay, some may not be strong enough, but we just need to improve there and ensure that there is information security whenever shared on this kind of system. Then the other concern is the integration of human capital, financial, and material resources. We are looking at this in Uganda. For instance, there's been complaints in our courts that some people file cases without paying filing fees. With digitization, you cannot avoid filing fees because the system will not validate your pleadings until there's proof that you paid the filing what? Fees. So that is easily K34. The issue of non-compliance with timelines for filing, people have been backdating. Is filing late, but is receiving a date which is earlier. With the electronic system, all that is dealt away. Then, as we shall see later on, efficiency of our judicial officers in terms of performance. Right now in Uganda, Jamson will confirm so, and I've been seeing it in court since we launched ECMIS, March 2022. Judicial officers are very active. They are working, disposing cases, giving shorter dates. Why? The system keeps a record of your performance. At the end of the month, it evaluates you whether you are performing or what or not. So this issue of saying I will not work is easily controlled because the statistics can easily be maintained by the system. Equally, when we see the aspect of electronic case filing I've talked about, it gives you filing at the comfort of wherever you are. You can file from your chambers. The registry can receive documents without you physically approaching them. So this is something we struggled with during the pandemic. But with digitization, this is also controlled. Then electronic case management system, there is a record of tracking a case, from the date of filing, you are getting notification of what is taking place on your case until the stage of hearing. As we shall see, Rwanda is a bit ahead within the region. I'll talk about also that statistics. ECMIS started in the East African Community region, started with Kenya way back in 2011. But Kenya is one of the countries struggling more using digitization. Actually, at a certain level, it had to abandon the digitization because, as we shall see, lawyers and judicial officers also have challenges with these systems. And we must agree here that some of us have not really embraced, and we have also those who have the mentality of calling themselves BBC lawyers, BBC judges, and those are the ones born before computers. So for them, anything to do with electronic system, they don't want to be what? Near it. But times where we are, it is unavoidable. We have to embrace it. So Rwanda has a bit far in this system and started it in 2016. But there was a very good designed program and the implementation system was a bit effective. Then the other, so we have, that is electronic record case management system. I want to be very courtroom technology. We can use video conferencing. We can have Zoom. We can tweet. In Uganda, we have done that during the pandemic, where courts were proceeding using Zoom technology, using video conferencing. Of course, there may be challenges, but at least it is a step ahead where you cannot be backward. The East African Court of Justice has also reached that level. Then the other concern, we have some, before we go to the challenges, when it comes to courtroom technology, we are trying to say that we can even have a hearing without going to the court premises. That can be achieved with digitization. But it is a gradual process. You may not start with that, but it is also possible. And we want to reach that level more so that the East African Court of Justice is based in Arusha. The national courts are scattered in different countries. So we can have a system of having our matters heard using this system, and I don't have to travel to Arusha to go there to present my case. I can still present my case while in Uganda, but the court takes all the record properly and makes a decision. So that's what we want to achieve. I must appreciate there are so many challenges with the digitization, which I can also highlight, like ICT infrastructure challenges. This is one of the problems we are having even with our ECMIS in Uganda, whereby the gadgets, technological gadgets needed may not be readily available, and some are very expensive. So you cannot, at the same level, think all courts will be equipped with ICT equipments. And so far in Uganda, we are using 7 pilot courts. But still, the issue of gadgets becomes also a big challenge. Then we have in the region also issues to do with the electric power supply, which is unstable in most countries, and ICT relies so much on that. And you could see even some regions, some places don't even have power completely, so it can be a challenge to have success of this system if that is not addressed. But these are issues that can be worked upon. Then comes a serious problem to a lawyer, to a judge, IT literacy challenges. This is one of the factors that is always a problem. Most of us were in school, IT was not very much emphasized. IT is becoming a global issue now. So we should migrate from the system of a judge coming to a courtroom and the whole table is full of files. All the files, papers torn, others not in the record, among other issues. So this is where the problem is. Even now, if you look at the courts within the region that have embraced electronic case management system, and courtroom technology, some have not taken away the files. They still operate with the manual what? Files. In other instances, you find these issues to do with electronic are left to the registry and the clerical staff. The judicial officers are not bothered whatsoever. So it becomes challenging to achieve it if it is not embraced by court itself. So ICT challenges becomes a problem, but this one can as well be solved by emphasizing too much training and also loving to have things change. And that takes us to organization and structure challenges, where you find that in some countries within the region, the structures are not in place. You find even the management itself cannot embrace digitization, and this becomes a drawback. We have situations where judges no longer call parties to deliver rulings, to deliver judgments. It is very annoying to go to court to receive a judgment, sit for 2 hours, enter court, they tell you judgment is not what? Ready. Then they adjourn, you come back again to receive a what? A judgment. Courts have moved away from that. Why should I go to court to receive a ruling? This can be electronically delivered, such that we save the cost as we are looking at access to justice. It also involves a cost effect. So judges have moved away from these that have embraced digitization. Even a hearing notice can be served electronically. Though here we have challenges of harmonizing the system and existing laws, specifically the procedural laws. I'm working on a paper in that kind of area. Justice Chavuri, you agree with me that when we launched the ECMIS in Uganda, for instance, our civil procedure rules, for instance, that apply for manual processes were not amended. You talk about somebody, you say, I filed my submissions electronically. You should be in position to see them. So, have you served them to me? For him, has gone back to the what? To the manual. Yet the system, and it's going to challenge you because the law has not dispensed with the deed of what? Service. Yet ECMIS is trying to address that and shorten. So if we don't harmonize the laws with the digitization, we are going to still have that digital divide and confusion, where some think technology is pushing us ahead, yet others are still saying we are proceeding manually because the laws still facilitate the manual kind of processes. So when we have to change our structure and attitude, it saves a lot of time. In Uganda, we have, for instance, Honorable Justice Musa Sekana, almost on a monthly basis. He's delivering rulings, judgments electronically. And you don't need to go to court. You get your decision fully and read it, understand. Then going to court, the judge is busy, send it to the registrar to read the ruling. The registrar also tells you the ruling is too long. Let me read you the last line. So you've wasted 3 hours waiting for that. So it doesn't make any sense today. This is something that can be delivered electronically and accessed at the comfort of wherever you are. 2 more challenges, then I wind up in the interest of time. We have policy challenges, and that comes also from the national level, and also standardization challenges. Now, this may be important if it is concerning now the East African Court of Justice. What system are we following on digitization of court processes? I think it should be a unique system known to all national courts and all participants or those who access such kind of courts, so that they know if we can file electronically, this is how we do it. Than some doing it, others are doing the manual, it causes a lot of confusion. And one reason why in Kenya, ECMIS was almost failed, because it was still operating alongside the manual system, and people were more comfortable with the manual than the ECMIS, being that it has technical challenges. So we can see there are quite significant challenges But some of those challenges can be addressed while looking at the way forward, which this paper has summarized and has given. I think it can be shared to all of you at the appropriate time. But as I conclude, we have to embrace digitization within our court processes to make service delivery, that is justice, more effective. Thank you.
Thank you. Thank you, Mr. Muchibi, for the visual convenience. I would prefer to sit here to keep an eye contact with our panelists. That was a very detailed presentation on some of the challenges and items that judiciaries need to take into account when undertaking such projects. And I would highly recommend everyone who is planning to do so take this presentation and have it right next to your modernization reform handbook. Given that I'm coming from a company that is helping judiciaries to modernize and digitalize their operations, I can hear you, I feel you, and hopefully this presentation will serve as a guiding document maybe for some people who are thinking of taking that path. So let us have a very practical discussion on this topic, and hopefully you will take some information from our panelists and from their answers to the questions that I'm going to ask home with consideration. So let me ask the first question, that is about the efficiency of judicial procedures. As Mr. Muchibi mentioned in his presentation, that was the first point in the strategies of digitalization. My first question will be to Justice Kamau. When we're talking about efficiency of judicial procedures, we naturally have these indicators in mind. What means to be efficient? When is the court efficient? When are the judges efficient in doing their work? So there is one indicator that pops up a lot of times in different documents, in different reports, by different independent organizations, by the judiciary's annual reports, etc., etc. It's the clearance rate, right, of the cases. So let's take this as an example, and let's hear Justice Kamau's thoughts on how digitization has impacted the clearance of cases, clearance rate of cases in the judiciary of Kenya. Please.
Thank you very much, Mr. Mukibi, for a good presentation. I wish you had sat next to me, then you would not have been too hard on Kenya, because we had been separated there. So I hope now we'll be able to speak properly. But the first thing that I wanted to do is just to maybe react to his paper as far as digitization of Kenya is concerned. Because what I felt him to say is that Kenya has sort of like not moved in those great strides. But I would like to mention that Kenya has moved very, very far. I take a respectful view. I think there are some judges here. The Court of Appeal, where Justice Kathrima Mtwainoti, also sitting in the East African Court of Justice, they are fully digital. They do not listen to any physical hearings. The High Court, of course, and other magistracy courts, we do listen to cases maybe sometimes physically. We adopt maybe a hybrid situation. And this is where maybe there are power outages, because if there's power outage today in my court, I cannot say that I will not hear the matters in court. What I'll do is that at least I'll allow even the advocates to even come to court and for us to be able to proceed. So that I would like to respectfully take a different view, and to also say that even where there's internet instability, then we might end up having, creating a hybrid. Because like the speaker has said, is that not all countries are on the same level as far as internet connectivity and stability is concerned, and even the different areas that we are in. Other countries, even in European countries, have been coming to Kenya to benchmark. So I think maybe Mr. Mukibi, that's why I was saying I needed to sit next to him here. But we are hoping that with the budgetary allocation, maybe with the new government having said that they are going to give an extra 3 billion, and operationalization of the Judiciary Consolidated Fund, which now has come to us, which means that the money now is going to come directly to us, then in that way, then we can be able to allocate resources to where we really need. So CTS, like we're saying, also is one of the issues that Kenya has done very well, because all our cost lists are generated from the CTS system. So in that way, we are able to look at the CTS and the performance management measurement understanding, where, like he has aptly suggested, that now judges and judiciary staff and judicial officers, we are all able to say that this is what I've done. It's accountable, it's quantifiable. So manual files are merely a backup, because you see, we are trying to run a system, but we want to say that in as much as we are doing transcribing, we might not have enough staff members to do that. And remember, for a long time, we've had a lot of budgetary cuts. So now going back, and that's the reason why I decided to just comment on that, is that you will see in Kenya now, during the pre-COVID, the cases were not as much. Because first of all, people are not being able to come to court, or maybe you come to court and you find your matters have already been, dismissed. But at least when you're sitting now virtually, you are ensured that at least even in your own house, you can at least be able to attend the matter at 9 o'clock when the court session starts. People are not moving up and down. When I was an advocate, we'd even miss hearings because you're looking for parking, which was a problem. But now with virtual, you're able to proceed. So our statistics, what we are seeing through the CTS, is that in the 2021-2022, over 400,000 cases were filed. And as a result of the very quick clearance because of using the virtual proceedings, we are over 380,000. So it means 95, according to my statistics, as of yesterday, 95% of the cases which have been filed, we have managed to clear. And in most places, we are finding that even clearance of cases is going way beyond the 100%. So we are chewing into the backlog, at the same time doing the incoming cases. And like we said, backlog is 1 year and above. Anything below that is not backlog. So on that basis, and the view of the civil procedure rules having been amended so that now we allow for electronic service through emails and through WhatsApps. So in that way, our digitization has assisted in clearing of the backlog very, very fast. And I think during the COVID period, when before we settled down, we sort of like cleared within about a period of about 3 months, we had cleared about almost 3,000 rulings were delivered electronically. And that's on email. And even now, we do not have parties coming into court physically to take their rulings. If that happens, then it's like I've said, because of the challenges that we have. But ideally, everything is done digitally. Today, when I'm seated here, I have been dealing with my matters from my court under certificate of urgency because it is done electronically. So I don't have to say that just because I'm out of the country, then I cannot deal with the matters. So I respectfully take a different view from Mr. Mukibi, but we will see whether we can invite him to Kenya. Then he can take maybe some tour. Then maybe he's been going to the wrong courts. So thank you very much. Thank you.
Thank you. Thank you, Justice Kamau. I referred to your speech as also half invitation for Mr. Mukibi to Kenya. So he can visit and see maybe what has changed. Thank you. Let's move on. Let me here another question, this time for Justice Kirabwire. We oftentimes try to understand what happens to judiciaries when technology is penetrating their operations and their daily work. But we sometimes fail to mention that there is a lot of preparation that goes into making this happen. So how judges or judicial officers prepare for digital transformation? What would you advise to those who are yet to experience this? And maybe you can share personally your personal experience, given that you are both a justice and also chair of the IT committee that is responsible for the implementation of ECMIS in Uganda. So maybe some recommendations from you for our audience members, please.
Thank you very much, David, and thank you, Mr. Mukibi, for your presentation. You raised the question, how do judicial officers prepare for digital transformation? And sometimes we get lost in the definitions and terminologies, but I will not go into that, because digitization is a very unique process, and we must be able to distinguish it from other processes like automation. The two are not the same, but the important thing to understand in terms of what recommendations you should have is to understand what is happening. And I'd like to start there, because when you know where you're going, then probably you can understand how to prepare for it. So when we're talking about transformation, we're really discussing what I would call a paradigm shift in work processes. When you understand that, then it becomes a lot easier. So at the heart of transformation, we really have like two levels. So you can have what Mr. Mukibi has been talking about, and that is the movement from paper to digitalization. So what you're saying is that how are you preparing to move from the use of paper to digital resources? So that is the first one. The second one is moving from what I would call manual systems to automated systems. So you have to deal with those two. And when you're dealing with those two, you're really looking at two broad areas. The first area is you're looking at the life cycle of a case. From the time it enters the court system, it is handled within the court system, it is heard, it is resolved, and then it exits the court system. So that is one area. The second one is how do you deal with support services? Because even if you're going to talk about case backlog clearance, you also have to look at management systems. You also have to look at support systems, human resource, security. So that is another transformation area that is taking place. Transformation also impacts institutional and structural matters. So, for example, you have to deal with issues of training. You have to deal with issues of equipment. You have to deal with issues of infrastructure. You have to deal with the regulatory environment. And Mr. Mukibi was talking about some of the procedures that may be out of sync with the use of technology. The big question is, what comes first? Is it the chicken or the egg? Are you going to bring the technology first and then put the rules, or are you going to put the rules first and then bring in the technology? That is a very big question that is always going on. So, like in Uganda, what we decided to do is we brought in the technology first, try to understand it, and then try to put rules around it. What we did is simply provide what was called a practice direction of the Chief Justice to encourage the use of technology. So the recommendation that I would give is, in preparing for transformation, you must have a game plan. You just do not decide that, oh, I see everybody is going into digital transformation, let me also jump into it. And I think most of the countries that have had challenges with transformation there is the copycat syndrome. They have not actually done the preparation. So, for example, in Uganda, we have had, in this regard, a IT strategic plan that has informed how the transformation is going to take place. So we have had the 2016 to 2020 IT strategic plan. Actually, I have a copy over there. I wanted to show it, but that has informed what has helped us to move systematically. Secondly, even with the ESCJ, we have a draft strategic plan for 2021-2025. That is also helping the ESCJ to assist in the transformation. So, if you want a seamless transformation, have a plan. Thank you.
Thank you. Thank you, Honor. Let me, without further ado, jump to the next question, this time for Justice Mutabazi. Rwanda is known for its, in the judicial domain, specifically for its IT capabilities, empowering judiciary members and judges to be more productive and to be more efficient. And my question to Justice is how technology is empowering you. Give us a before and after look at Judge Mutabazi with technology in his hands and without technology in his hands.
Thank you very much, David, and thank very much my fellow panelists and the presenter. Well, talking about how technology has empowered me, I will speak till the cows come home, but I'll try to make it very brief, as you said, before and after. I joined the bench in around 2002, 2003, at the work where in our country, the court that was assigned to were trying cases of genocide against Tutsi. And in those cases, you will find sometimes you have suspects that are going 100 and more. And sometimes you had to take the files to try them on site. So you can imagine cases that have 100 and plus people, and imagine the bulk of files they had. Sometimes we had to get vans to transfer the files to the site. So you can imagine the labor, the registrars, the judges they had. First of all, the judges to go through all the bulks of the files that you have and analyze, and then, but secondly, the registrars to transfer this to this. So I can never say, it's as I said, I will talk about this till the cows come home. It has definitely changed my work life. Secondly, I would say as a judge, but also as a head of a jurisdiction, I headed a jurisdiction after that, before the introduction of the ISMS. Actually, ISMS is Integrated Electronic Case Management System, which means all files into the courts on the justice system, they come through electronic methods, nothing more in our system right now. So I would say I headed a jurisdiction before, and in the morning you will find almost 80, because it was a busy court, 80 litigants that are lined up in the registry and elsewhere in the corridors coming for services. First of all, they're coming to file. Secondly, they're coming to look after their and see when are the dates due. Secondly, they're coming up to take summons and take them to serve. Thirdly, they'll come for a hearing. Fourthly, they'll come back for a judgment copy. Sixthly, they'll come back for an executory seal and all this. Thirdly, they'll come up for enforcement and all this. So you see all that was happening in one court that was happening. But after, as I said, that is the first January 2016, that is when we introduced the ISMS. It was not very easy because definitely we knew this is something, as the presenter was saying, that there are members that were before the computer that were born there, something that was very hard. There was resistance, not only from the court officers, but even the court users, the litigants, the lawyers, and all. They were saying, what is this? What are you introducing? Are you very sure that this is going to happen? But I am saying that this daring decision that was taken yielded. First January 2016, that is when we rolled out 16 with a pilot phase, 16 courts from January to September. Then after September, we had the entire country now up and running with SMS. How has this impacted me? First of all, as I said, as the head of the jurisdiction, it was introduced when I was still ahead of a jurisdiction. I hadn't been elevated to the High Court. I saw a drastic drawback of litigants that were coming on the courts, and that was very impressive to me. It was something like a nightmare. Of the court that you're working in, and in the morning you find the litigants that used to be like 30, 40, 50, 60. Now this time you're seeing 8, 9, 10 coming on a row. That was something that was very impressive. Secondly, as also a court administrator, it was very easy to follow up on the workflow in the court. Know what the judges are doing, know the cases that have been adjourned, know who is doing this, and all that was something that was very easy to handle on this. Know how you can plan for your court. Definitely, I know I have this number of cases without going and counting. I will tell you, now these cases that we're saying, there's a time we had containers in the court that I had when we were still using the physical. And we'd pile them in containers, and there's a time the space in the containers were getting over, and we're saying, well, now what is going to happen with this? We can't do anything with the case. We're supposed to have them for records and all this, but so that was our dream came when we had ISMS being introduced. So as a judge, definitely this helped me very much. As I said, carrying papers and all this in the court, that was done away with. Secondly, consulting cases from ISMS, knowing what has been decided in the Supreme Court, in the High Court, and the Court of Appeal, very easily. You can go and search and have it. Thirdly, the tampering of evidences, sometimes that used to happen in the physical courts, it died down. It's very easy to track and know who is trying to tamper in the system, who is trying to delete something because of the trails that is happening. That was fantastic. And overall, knowing how the functionality of the court is happening. So I would say, as I said, I would speak on and on till the cow comes home, but it's very much changed to me since before the introduction of ISMS and after the introduction of ISMS. Thank you so much.
Thank you, Your Honor. I also take your words as compliment for my team, who was happened to be the team behind the implementation of the ICMS in Rwanda. So I'm sure my colleagues will be happy to hear your words on that. Before I have one more question for Mr. Muchibi, but I want to see maybe from our audience. Are there any questions from the audience that we need to, okay, I see 1, 2, okay, thanks. I will make a note of that, and I'll ask Mr. Muchibi one question, and I'll go back to the audience. Mr. Muchibi, so you talked in your presentation about the digitalization of courts, of judiciaries, but I also had a chance before our conference to have a look at your other publications, and you are covering not just judiciaries, but other public institutions. So my question is, what makes judiciaries different when undertaking digitalization projects or reforms? Are there any nuances, details that judiciaries need to take into account that are specific to them when compared to other government entities? Thank you.
Thank you, David. I will highlight two issues. One, judiciary serves the interest of justice in every country where it is established. And I also take note that there are other institutions of government that also deal in service delivery to members of the public. Judiciary is dealing with so many critical issues that even touch life and death, and access to justice, as we discussed in the morning, is something very, very unique that needs to be taken seriously. Why we are more careful and we are very, very pertinent about the digitization, we need to see that justice is properly administered regardless of the digitization system. However, it does not mean that it's only the judiciary that has embraced digitization. In Uganda, for instance, we have other public entities. Ministry of Lands started way back the Land Information System, and they are doing well, though not yet where we expect them to be, but the system is running. We have URA, whereby now you can easily pay taxes, you can be assessed electronically, you don't have to do the usual manual system. Talk about URSB, the Uganda Registration Services Bureau. They have also digitized their systems. You can get an assessment, you can access company records, you can conduct a search electronically, you can even get a certified information from that office without going there. So they have also digitized their system. So this is happening elsewhere, though what concerns us in the justice system is the court and service delivery, but it is not only the judiciary embracing this.
Thank you for the answer. Now, let me turn to the audience. I see a couple of hands. I'll ask our team to, yes, pass the microphone over there to the gentleman. Please introduce yourself, and we will be happy to hear your question. Maybe the sound responsible team can help us with microphones. So, before the question, let me give the floor to Justice Kamau, who wants to add something to her speech, please.
Thank you so much, David. The only thing that I wanted to just clarify is that even as much as Mr. Mukibi had talked about those issues, it's to still admit that it did take us as Kenya, just like in any other place, a lot of effort, because remember that digitization improves a lot of transparency and accountability. So now we are able to know who has caused the adjournment, because the adjournment will show that parties were not ready, but all the advocates were not ready, because initially what clients would do, what advocates would do, they would lie to their clients and say that the matter did not proceed because either the court was not ready. But now this information is there. So I want to say that initially there was a lot of resistance, because any human being, just like we've had people resist, and they do not want to be too, they want to be a little bit opaque. And so there was a lot of sensitization that was done, both to the judiciary and even our stakeholders, because even without the stakeholders also being on board, if you insist on proceeding virtually, and they also do not have that capability, or they have not learned, then it becomes a bit of a challenge. So thank you so much for allowing me that opportunity. Thank you.
Thank you, Justice. Now, yeah, please.
Yeah, thank you very much. I'm called T.O. Milton. I'm a director with Uganda Prison Service, but right now I'm representing my boss, Commissioner General of Prisons. Although here it is written Biabasaija, but I'm not Biabasaija. Let the record be put very clear. I'm just standing for him. I'm just here testifying as Uganda Prison Service. I just want to agree with the presenter. First of all, I want to thank you for that nice presentation. As Uganda Prison Service, I want to tell you that if these digital courts were not there during COVID time, I think we're going to have trouble. Why? Because every week, people were being arrested, those who violated COVID rules. So we're going to have our cells filled with human beings and nowhere to dispose them. But this court, this digital court really helped us a lot in decongesting prisons during that period. Even to make matters worse, all of us were under quarantine. Where were you going to get staff to take prisoners to court? And the judicial officers were not there. So really, it was a God-sent technology for us. I just wanted to testify that. Secondly, this is a question. Mr. Presenter, how ready are you to remove this attitude from the Wananchi? That this system has come not to offer justice, but it is injustice itself. Because our people think if they can't see their people physically in court, you are actually denying them justice. And they feel that their people cannot get things like bail when courts are digital. How can you remove that? In short, everything has been politicized. For those in Uganda, you know our politics now. And most of these people we're having in prisons, many of them are from certain angles or parties. And when you say these are the ones to appear in these digital courts, I tell you, we have to use all our brains to convince people. It has highly been politicized. How can you help the country to remove that? Thirdly, and the last, this one somehow also touches my good doctor who criticized plea bargain. Me, as a head of prisons, I'm very comfortable with plea bargain. Why? Because for the last time, rather for the first time, after very many years, I now have more convicts than remands. For example, right now, I have 37,370 inmates who are convicts. Then I have 35,684 prisoners who are on remand. Why am I bringing this point? I want to connect it to digital courts. How, as for us in Uganda, is it ready? Are you ready for us to begin plea bargain even on digital courts? For me, I'll be ready to impress that. After all, personally, I'm in charge of prisoners in the country. I will impress it very fast, such that my joy is to have more convicts than remands. I may not tell you why, but that is the way to go. So for Uganda, when are we bringing digital courts even to do with plea bargain? Then lastly, East African Court, how ready are you for these courts? Because I have a prisoner who has already filed a case in East African Court of Justice. How ready are you to utilize this? Thank you very much.
Thank you. Thank you for the question. Let's take a few more, and then we will go to the answers. I saw, a question from gentleman in blue shirt, please.
Mr. Mukibi, good afternoon. You got the Kenyan perspective from the bench. I am from the Kenyan bar. I will give you the bar's perspective. I don't know where you got your information, but you need to verify it because as far as the general rule in Kenya is concerned, we are conducting our court sessions online. That's the general rule. The exception is with 1 or 2 criminal cases for purposes of dealing with witnesses, and only then do we go to court. And since we are, I believe in evidence-based cases, I want you to verify online if you have your phone or laptop with you. To my right is a judge from Naivasha, Kenya, Justice Mwongo, quiet judge seated to my right. He has delivered over, I think this is 2,000 judgments since 2020 June. And for me, who is a public interest constitutional law practitioner, the judge has accounted to me and the Kenyan public, and it's accessible online. Further, we have a deputy registrar wholly dedicated to digitization, and he is in charge of steering the process. So I think the sources of your research might have misled you. Kenya is doing considerably well with its challenges, but we are fully digitalized. Thank you.
Thank you for the remarks. We definitely need Mr. Muchibi to maybe clarify some of the things that he mentioned in the presentation. Now, the next question, please. Yeah, lady over there.
Good afternoon, everyone. My name is Nema Lugangira. I'm a member of parliament from Tanzania, but also chairperson of the African Parliamentary Network on Internet Governance that has about 36 members of parliament, about 26 countries. I have 2 comments. The first one is I wanted to get the opinion of your panelists that do they believe that the use of digitalization in our court systems can contribute towards prisons decongestion? Because at the moment, in many of our EAC countries, the number of remands is more than the other, and that is mainly because of the long time it takes for these people to get justice. So I'm just wondering, how is that linked, or how are they seeing it? Because I am of the opinion that, you know, having a large number of remands in our prisons costs our governments a lot of money. Even if we just look at the food bill every month, because as per the human rights law, they're not allowed to work. So even the food that is being produced by the others who have already had their verdicts. So in a way, you know, if we work towards reducing this number, not only are we going to free up the space in our prisons, make the environment healthier, but also save our government's money that can go towards development projects. That was number 1. But number 2, to use digitalizations in our court systems, it means there's a need of data protection. And I was pleased that the presenter talked about data protection. But out of in our EAC states, EAC member states, not each and every member state has a data protection act in place. I'm actually very pleased that in Tanzania, on 22nd of September, the government, through the ministry responsible for ICT, tabled a data protection bill, and we hope that we'll discuss it in our next parliament session that starts next week. However, if each and every country has got its own data protection bill, yet we have an East Africa Community Court, is there a need to have an EAC data protection bill that can bring harmonization or not? What is your opinion? Thank you.
Thank you. So let me first let the presenter and panelists answer the questions, and then we will take a few more. So Mr. Muchibi, maybe you can elaborate on the first 2 questions. I think those were addressed to you, and then I will repeat the question for the panel after you. Thank you.
Thank you. I'd like to thank all members that have contributed and also raised important questions. I'll begin with the representative of the Commissioner General of Prisons. his more was to appreciate the digitization system in respect of prisoners. And this worked out well during COVID-19, as he said. We had a video conferencing facility that helped to decongest. But he has raised pertinent issues, which I also pointed out. Some we are still struggling with. Justice Chiare has posed the question, what comes first? Is it the law or the technology? There are so many questions to do with access to lawyer in the criminal justice system. An accused has a right to consult his lawyer in confidence. Can you do this virtually? When you are having, for instance, video conferencing, somebody is in prison and the proceedings are being administered electronically. There are some of those issues that keep coming, and some believe that the courtroom technology, like video conferencing, is denying accused certain rights given them under the Constitution. There's also that argument. But as we said, this can all be worked upon if we are to streamline the system positively. And to answer the question clearly, how do we remove that mentality from the people that digitization can still realize access to justice? I think it's your duty, it is my duty, it is the duty of the bench. One, constant sensitization. If we don't ourselves believe in it, like many advocates have negative perspective on it, then how do you expect those people to believe in it? So it starts with us to embrace the system, then we can help those ordinary people to understand how the system works and to assure them that their rights can easily be protected. Coming to my sister Honorable Justice Kamau and my colleague from the bar about the statistics in Kenya, I think the challenge may be in a publication of your statistics. The records giving us published? Because when you search about Kenya, what you will get may be something different. Maybe the challenge could be in publishing your records about digitization system. That may be the challenge. If you also search, you may realize what you are getting. Like you've talked about the 2,000 judgments delivered just in 2022. Do we have this information published as an attribute of digitization? Or somebody cannot know how the judgments were delivered. So statistics have to be published on this system to create awareness of how it is moving. If you look at Rwanda, the records do exist, they are published. Tanzania, Honorable MP, I saw Tanzania just launched digitization in 2021. It's just starting the process, as you said. And as to whether the ESCJ will realize the rights of these persons while using digitization, I think Justice Chiare will talk about that. But it is all about attitude change and also making others aware that it is possible. Thank you.
Thank you. I'm being warned by the organizers that we are very much behind the schedule. So let me just quickly address the question of prison decongestion to our panelists. Where do you see the link between prison decongestion and digital courts? Would anyone like to take that question from our panel? Just briefly maybe elaborate on that. Please,
right.
Justice Kamal.
Yeah, thank you very much. I think I'd like to take that question just to give my input and say that as far as this digitization is concerned, like where I come from, remember that we talked about lack of resources. So with the prisons, they were also struggling to bring the remandees or the appellants, already convicted persons, to courts because of maybe there's lack of petrol, there's lack of fuel, and that kind of thing. But now when I do my cases online, they are able to file their submissions online because we have on email. So far now at where I work, we have not gotten into the e-portal, Mr. Mukibi, but we hope that by November, December, we should have been able to get into the portal so that we are not even using email. But once that happens, because if these people are able to listen to me, I listen to their case immediately, and they file their submissions having given the timelines, then you're able to deliver your decisions also online. So in a way, we have really managed to reduce even the backlog of cases that we used to have. So for me, I see digitization has some sort of connection with decongestion of prisons. Thank you.
Thank you. Yes, please.
What I will add on is not only in the prisons, but also in the cells. I would say that we tried this during COVID time in Rwanda when we were under confinement, even in the cells that we were doing. The judges were in the courts and then the inmates were in the cells and things were working. So it can not only be only in the prisons, even in the cells, in the prisons, in the police cells. That is what I'm meaning. They also can help. Thank you.
I'll not say too much. I think the issue has been nailed. The answer is yes. And I think Afande Tio has given the statistics for Uganda, so it is possible. Yes, there are human rights concerns about rights to prisoners' access of counsel. Those are things which we need to work around to make technology more efficient and more effective. I can speak about readiness at the East African Court of Justice because we have Afande been actually hearing cases out of Kitalia straight into the EACJ, where your prisoner has been able to appear in court. So preparedness, yes, and actually perhaps what we should say is now also our partners are starting to get ready because now even the prison service is starting to be able to provide the necessary infrastructure that we can use to have cases heard even when somebody is in prison. Yeah, thank you.
Thank you. One more question. I see a gentleman here. Please. But before that, there was a question about the Data Protection Act between members of the Eastern African community. Let me take that question and mention that this, I guess, it doesn't only have to do with digitalization of courts and data exchange between, let's say, the system in Kenya, the system in Rwanda, the system in Uganda. So it's a more, I would say, complicated question that the community would need to address at some point in its development. And then, as it said, once the rules are there, when we are going to digitalize those rules, then it would be much easier when you have an already working framework on paper to digitalize that system. You can take the example of, for example, Uganda, where you digitalize and then modify and adjust the rules. But for such a big enterprise, I would recommend having something on paper that digitalization efforts will cover. Please.
My name is Bishop Samuel from Ministry of East African Community. My question goes straight to Justice Kiabwiri. How do you assess the demeanor of a witness using the electronic hearing system? Thank you.
How do you ensure that the system is not tampered with? And if it had happened, what was the remedy? That is all.
Did you get the question, the second one?
Yes, I hope I did.
Okay.
Yeah. The system that we apply in the courts is audio-visual. we do not have a trial by audio. So we do have an audio-visual system, so you're able to see and you're able to hear. There are times when it will not be as good as if you are physically present. Now, IT, for me, I take it as a tool. I don't take it as a silver bullet to resolve everything there. And I would like to say that there are greater challenges if you're doing trial which is purely audio, and I have had some simple applications of that nature are handled in the United States. I have no experience of that within our own jurisdiction. So that is a new area, and I don't think at least for Uganda, I don't think our plan is to go into audio trials. We're really into audio-visual, and I can tell you, you can see a lot with what is happening on video. Of course, the challenge comes with my senior brother, the VP Emeritus, say, how do you deal with integrity? We have had IT systems also being degraded by people who are using them. And so integrity of the system is very important. I think that we had one trial when someone said, I cannot speak because there's someone with a gun. There's someone with a gun, and you turn the camera, there's someone with a gun. You know, so there are those challenges which are there. So one, when you're going to do these systems, you need to work out the integrity of the place. And the Ugandan rules which we're now making are addressing that. If you're going to deal with where the video source is coming, what are the minimum standards that should be in that location before you can take that evidence? So in answer to your question, yes, you can decipher demeanor. Like in that particular case, it was very easy for the panel, and I'm very happy that the entire panel is in this room. That person was just playing games. He was just trying to make proceeding difficult, and it was very evident that he was play acting. So that demeanor, we realized that he was a player. So it is possible. And for the rest, I think my brother Lebois, we improve the systems. We learn more, we improve. We learn more, we improve. What is not possible is to say that technology is going not to take. It's not going to happen in the courts. That where the ship has already gone out of the harbor. Now it is just management. Thank you.
Thank you, Justice. Due to time constraints, we will not be able to take any more questions, but I can see in our program that we have a networking session in the end of the day, so I'm sure our panelists are ready to answer your questions during the networking session, so feel free to approach them and pose your questions. For today, I'm happy to conclude our session. Thank you, Honorable Justices. Thank you, Mr. Muchibi, for your contribution, and thank you for our audience for your questions. We'll be happy, again, as I said, help you during the networking session. Thank you, everyone.
Thank you very much. May I kindly request that we all stand up? Kindly stand up. And do a stretch, a shake, whatever works for you. You can do some kicks as well from where you're standing. Thank you very much. You may now sit. I want to thank the participants in the just concluded session. Thank you very much for the knowledge you've been able to share We thank you so much, Mr. Muchibi, for your very informative presentation. We are now going to move on to the last session of the day, and that's the session titled Access to Justice and Equality Before the Law, Removing Barriers at National and Regional Courts. May I kindly request the Honorable Justice Kathurima to come and take his seat, Mr. Francis Gimara, Ms. Susan Pony Victor, Ms. Lilian Berugaba Adrico, and Mr. Jean-Claude Barakamfitie to come forward. Kindly, let's move fast. People have sat for quite a long time, and it's in the interest of all of us that we wind up the date sooner. Thank you very much. I'll start by introducing our moderator, who will then introduce the presenter and the panelists. Justice Kathurima Mtoinoti is a judge of the Court of Appeal of Kenya. He was appointed to the EACJ Appellate Division in February 2021. He has served as the chairperson of the Law Reform Commission and practiced law in Nairobi for 13 years, specializing in constitutional litigation. He's also a former lecturer in the Department of Public Law at the University of Nairobi. He has also served as a commissioner of the International Commission of Jurists in Geneva, Switzerland. Justice Kathurima is also a former member of the Executive Committee of the Commonwealth Association of Law Reform Agency, and he's a former president of the Association of Law Reform Agencies of Eastern and Southern Africa. He holds a bachelor and Master of Law degrees from the University of Nairobi. He's a fellow of the Chartered Institute of Arbitrators and has been awarded the Elder of the Order of the Burning Spear and the Order of the Grand Warrior for his contribution to law reform in Kenya. He was a recipient of the Law Society of Kenya Distinguished Service Award for the administration of justice in 2016. You're most welcome, Justice Kathurima.
Thank you very much, Christian. Colleagues, good afternoon. Let's agree that we have been through protocols, so we're not going to take more time on protocols. Our session was supposed to come to an end about 3:30. Now it's already past 4:30. So we're going to try as much as possible to be focused on the issues before us. One thing we do in the judiciary, we have completely refused to accept that limiting time for litigants is a violation of the right to access to justice. Those people who come before us asking for 3 days to argue an application that needs only 15 minutes, we have always insisted on strict time observation, and it has worked for us. We do not consider it a violation of access to justice. I will look very selfish because Christine has been very elaborate in introducing me, but we have 4 people that I need to introduce, and unlike Justice Ogora, who abridged their very long CVs, I propose to massacre the CVs for purposes of time. So I'll be quite direct on the time. I propose to introduce all our speakers, the presenter, and the 3 panelists, so that we do not take a lot of time after that. So starting with Mr. Francis Gimara, our presenter, he is the managing partner, African Law Practice Advocates here in Uganda. He also heads Africa Law Practice Group in Uganda and in East Africa. He owns a Bachelor's of Law degree from Makerere University and a Master's of Law degree from Cambridge University. He has a diploma in legal practice and in business administration. He's a former president of the Uganda Law Society, and currently he chairs the Public Procurement Disposal of Assets Appeals Tribunal. Our first panelist is Ms. Susan Pony Victor. Ms. Victor is the Executive Director, International Federation of Women Lawyers, FINDA, South Sudan. She owns an LLB degree from University of Juba and also a Master's of Law degree from the same university. She has extensive professional experience on matters of access to justice by vulnerable groups such as girls, children in war, and prisoners. Our second panelist is Ms. Lillian Biarugaba Andrico. Ms. Andrico is the Chief Executive Officer, International Federation of Women Lawyers, Uganda. She owns an LLB degree from Makerere University, a postgraduate diploma in legal practice from the Law Development Center. She has also extensive legal practice and experience on matters to do with civil society issues. Last but not least, our last panelist is Mr. Jean-Claude Barakampitie. My brother allow us to call you just Baraka. It's a beautiful Swahili word and name meaning blessings. Baraka is a member of the Burundi Bar Association and CSO Linda. He owns an LLB degree from University of Burundi, an LLM in Intellectual Property from Africa University Zimbabwe, certificate in conflict transformation, Vermont, USA. He's a co-founder of Burundi Bridges to Justice and managing partner, BK Law Group. He has also done extensive work on juvenile justice and human rights advocacy. Without taking more time, let me welcome Mr. Gimara to make his presentation. Mr. Gimara is a regular practitioner in the regional court, and we all admire him because of his precision. When he's doing a matter in Kampala, he does not start in Mombasa and go to Juba and then end up here. He comes straight to Kampala. Mr. Gimara.
Thank you, my Lord Chair. I know that you have exempted us from protocol, but it's very difficult for lawyers not to at least recognize, just allow me to recognize the President of the court and their lordships in the room, ladies and gentlemen. I think it gives us a good preamble to start the presentation. I have been asked to speak about access to justice and equality before the law, removing barriers at national and regional courts. I will not dwell a lot on what these definitions mean. I mean, the topic is a mouthful. It is an elephant. You just need to locate where you can hold it from, which angle to take it from. And I have decided to look at it very briefly as a practitioner, and I will speak from that angle. Access to justice and equality before the law, as we all know, are two commonly and oftenly banded together terms in legal, human rights, and social justice circles. Interestingly, though, a cursory look at the national constitution of the partner states of East Africa finds scanty mention of access to justice. Only Kenya's 2010 constitution has a provision on access to justice for all, and it is contextualized to reasonableness of fees as not to impede such access. Admittedly, all partner states' constitutions provide for and guarantee equality before the law and attendant equal protection of the law. Nonetheless, this has not stopped the partner states, especially their national judiciaries, as Dr. Kabumba demonstrated earlier on, from seeking to ensure equal access to justice for all. On its part, the EAC Treaty is silent on both phrases, but instead embodies concepts on good governance, rule of law, human rights, and social justice. Notwithstanding the scantiness of access to justice in constitutional frameworks, the phrase lends itself to and informs human rights principles in constitutions and by and large has a nexus with the fundamental right to equality before the law. In access to justice, justice is essential, is an essential term, as it is the only thing that matters in the end. The concept of justice itself is based on perceptions of the rule of law, which is informed by the idea of equality. The rule of law, ladies and gentlemen, as we know, enjoins that all individuals or persons are equal before the law, and in the context of justice and access thereto, it requires that everyone should be treated equally. Notably, the existing modalities for access to justice at both the national and regional setting in the community is based on judicial processes through courts. In effect, both national courts and the regional court are essential actors in the state of access to justice and equal protection before the law in the East African community. And in that context, this year's annual EACJ Judicial Conference theme on transforming access to justice in the East African community speaks volumes to this critical issue. Do the national citizenry and the East African residents access justice and enjoy the equal protection of the law? What barriers exist or are placed in accessing justice and the law's protection? Are national courts and the EACJ playing any identifiable role in addressing and removing barriers? These are the questions I will now attempt to answer, and I will be done. Conceptually, access to justice is, as already noted, the means by which recourse is made to primarily judicial processes. The processes may be formal courts of law, as by law established, tribunals, or other informal and traditional systems of justice. It has procedural and substantive tenets. The procedural tenet entails the access to courts. This is, as you know, important in rendering the justice system more user-friendly, effective, and accessible. On the other hand, the substantive tenet looks at the fairness of the legal system and procedures and laws in place, that is to say, access to just outcomes. Access to justice enjoys defining and understanding the meaning of justice as a term that generally brings to mind notions of fairness, accountability, and equity of outcome. Justice is a powerful driver in adjudication of disputes, enforcement of rights, and is a powerful tool in strengthening the rule of law. This is important given that claims, rights, and freedoms are meaningless if there are no means for enforcement or consequences for their violation. Oftentimes, the expectations in suits before national courts and references before the EACJ is to obtain remedies that ensure compliance with the treaty and the law generally. On its part, equality before the law is a central tenet of a fair and just legal system, serving as a procedural means to safeguard the rule of law, and conceptually it seeks to guarantee equal access to all persons to and before courts and tribunals, and proscribes any form of discrimination of the parties to the proceedings. Now, my reflections concerning the efforts to address barriers to access to justice and equality before the law. So much literature has been penned and much discourse had in relation to barriers to access to justice in many countries. This presentation shall not seek to dwell on all or many of these documented barriers. Like I said, I will look at it from an angle of a practitioner. Without doubt, equality before the law and centrality of access to justice much as they are lofty, we still have instances where barriers exist. And by and large, the primary and foremost barrier to access to justice and equality before the law is the legal framework itself. The legal framework or system is and remains apt to create barriers in the way it works and operates. I have identified 4 barriers. One are the procedural barriers, in form of the procedures to be taken in order to access the courts and in effect justice. The second is legal standing in accessing justice. The third is delays in delivery and dispensation of justice. And the fourth is complexity of the legal framework and the legal system itself. Let us look at procedural barriers, beginning with national courts, as well as the regional courts. They dispense disputes on the basis of procedures. The traditional common law countries of the EAC, Kenya, Tanzania, and Uganda, have varied procedure and related rules for litigation of civil matters in relation to civil claims to labor disputes, judicial review of administrative actions to family and matrimonial causes. Rwanda has an omnibus law on most of these areas. In the same vein, South Sudan has a procedural law, like we are told, inherited from the Sudan and dated to its Anglo-Egyptian colonial heritage, covering civil claims, conflict of laws, arbitration, constitutional matters, and the judicial review of administrative actions. On its part, the EACJ, as the regional court and dispense of justice to residents of the community, is accessible by way of rules of procedures. The court has its own rules of procedure 2019 that replaced those of 2013. Sadly, too often, the procedural laws or legal frameworks create barriers to access to justice. The legal process and procedures are steeped in specialist language and legalese and create more hurdles as judicial officers and legal professions struggle to apply procedures. This is in spite of great efforts, often at the initiative of national judiciaries through the rules committees, to put in place revised or new procedural rules and practice directions to enable access to and expeditious dispensation of justice. In Kenya, the judiciary has over the past decade issued practice directions that include, among others, procedures before the High Court 2021 and the Supreme Court 2020 and e-case management 2020. In Uganda, the judiciary has in the past 4 years issued 11 sets of revised or new rules and directions. In 2019, 6, 2021 they issued 1, and 2022, 4. However, these innovations have posed their own challenges. In one instance, in response to the new procedural rules in civil litigation matters, a trial judge had to admit to having, and I quote, open quote, take cognizance of the fact that the amendment rules are still new and they introduced radical positions that would require transition, close quote. In this, the trial judge was admitting that despite the rules being in place, they would require a transition, you know, in terms of training, and of course, understandably, the challenges faced by courts and legal practitioners in the use of the rules and directions, thankfully, is rectifiable by training. The national courts and the EACJ as a regional court have encountered and deal with procedural barriers. One which I would like to highlight is the timelines for expeditious filing of applications or references. Oftentimes, procedural rules set timelines in which to file matters. Uganda's judicial review, for instance, require a challenge of an administrative decision to be filed within 60 days of the decision. However, the rules also allows for extension of filing timelines. This enables access to justice in deserving cases. However, this is contrastable with the similar 60 days timeline in filing of references before the regional court. The treaty that introduced the timeline by a 2006 amendment does not make exceptions, and as a result, the EACJ has adamantly taken a strict factual approach to the 60 days timeline. The result, like we all know, as practitioners, has been a denial of access to justice before the regional court in numerous references. So we have a huge barrier. The court cannot be faulted, but this is a matter that I hope will be taken on by the other organs to redress this 60 days rule. It is a huge barrier, disabling access to justice by many citizens in East Africa. On the other hand, secondly, in spite of time-based barriers, national courts and the EACJ have sought to overcome and have addressed potential procedural pitfalls. It's not all dark. An area of potential procedural pitfall has been the locus standi, or legal standing to file matters or references. National courts have exhibited the willingness to embrace liberal locus standi approach, in particular as regards public interest litigation. On its part, and commendably so, the EACJ ought to be lauded for nipping in the bud the early attempts to challenge locus standi of EAC citizens and residents. As early as 2006, in its first cases, the EACJ affirmed the direct right of access of EAC residents to the court without a need to exhaust local remedies in national court. This, I must say, is very important since it has enabled EAC citizens and residents to have a choice of forum where to access justice, either through national courts or regional court or both concurrently. Additionally, the EACJ has, in its proactive and liberal approach to locus standi before it, ensured and emboldened public interest actors as well as amici to engage in it on matters of enforcement of community law. Notably, the EACJ embraced the amici as ally in a role played by ELS, expressing gratitude for able guidance it gave to the court. This was seen in the case of Calist Matela and two others versus East African Community. The EACJ noted of the Law Society's role as amicus in the following terms. We would like, while commending all counsel who appeared and addressed us in this case, especially to commend the very useful and helpful submissions addressed to us by counsel for the amicus curiae, who very ably and cautiously assisted the court without any attempt to side with any party in the reference. The court, as a friend of amicus curiae, was guided accordingly. The jurisprudence of the court has now percolated, and I recall that in the presidential election petition of 2016, the Supreme Court of Uganda, for the first time, admitted amicus based on the precedents established by the East African Court of Justice. This step must be lauded as the court is conceding that to access, opinions to enable you make good decisions is not a sign of weakness, but actually as a friend of court, you in a way are contributing to justice and helping the court to appreciate the issues before the court. This is something that is positive. So AMICA is gaining traction, and it is now in all the practice directions, particularly in Kenya and Uganda. One thing remains, though, the nexus between national courts and the EACJ as a regional court has to be improved. We still await for the use of preliminary references as a mechanism in a much more deeper way than what has been happening before. On procedural barriers, it may be necessary to close with what may be regarded as an attendant barrier in relation to applications for preliminary orders of EACJ. I think there's still a problem in regard with preliminary orders. it is not possible to get a quick interim order to deal with matters of urgency. This is something that the court should look at, because when parties come before the court, they need to get remedies. On the issue of preliminary applications, there is still much more work to be done. I have proposed this paper will be circulated. In the interest of time, some of the things that court can consider. The other issue, quickly, Chair, in 2 minutes, if you may, the barrier of physical access. That is still across the national courts, but as well as the ESCJ. But I think that the idea of having registries established across the countries by the ESCJ should be commended. And now, by getting the courts to move every year into another place is also something that is enabling access to justice by the court. I would like to say the third issue on technology has been dealt with very, very intensely, but I commend the court and also implore the participants that it is time to embrace technology. Technology, indeed, like the panel has demonstrated, and I've put it in my paper, is something that will enable access to justice for many. And just like Justice Kiriabwira said, it is more about a tool. It is a mechanism. You remain with the content, but it enables many people access justice and affords equality. For us practitioners, just the fact that we can submit from our offices is very cost-effective, not only for us, but also for the clients who would not otherwise have afforded to pay for the tickets for the lawyers to fly to Arusha to prosecute these matters. So we must commend that. In my concluding remarks, I am saying that barriers to access to justice, and in effect equality before the law, in form of procedures and physical accessibility or other barriers will continue to subsist in the national courts as they do at the ESCJ as a regional court. Certain, of course, some of them will be constrained by human resources-related barriers. These ones, nothing can be done, but I'm imploring the court that where they have discretion to innovate, they should stretch their innovations to provide access to justice for users. For instance, they can take proactive and even judicial activist approaches to court procedures to enable ease and expansion of access to justice. And secondly, they can take advantage of opportunities offered by technology to innovate and on access to justice and enhance equality before the law. But also on judicial activism to dig much deeper and originate a unique African jurisprudence that is acceptable for many users so that they get justice from both the national courts and the regional courts in the manner that they understand. I want to say thank you so much for the opportunity to share these thoughts from my perspective. Thank you, Chair.
Thank you so much, Mr. Gimara. I knew we could count on you to be very, very precise. Mr. Gimara has built on the presentation that we had in the morning from Dr. Kabumba. Dr. Kabumba identified various barriers to access to justice. You know, he put them in terms of language, history, socio-economic, religious barriers. And this afternoon, Mr. Gimara has built onto that. In fact, I really like the distinction he's making between accessing courts and accessing just outcomes. I think it's a subtle point there, and I think it's very, very, very critical. What we need really to be focusing more is not just getting people in court, but at the end of the day, being able to assure them that actually they'll get just outcomes. He has identified quite a lot of problems with the legal framework, matters to do with procedures, issues to do with local standard, delays in delivery of judgment. And I think he has also done very well in terms of identifying some proposals as to how we can overcome these barriers, both nationally and at the regional level. What I propose to do now is I do not intend to ask any kind of questions. We have our three panelists who come from very different backgrounds. And I think it would be fair to give each one of them about 5 minutes to add into what we have heard from Mr. Gimara to try to conceptualize these barriers and solutions from the area that they themselves come from. We have people who have been dealing with issues of access to justice from the point of view of women, from people in prisons, from children, and the other contexts. And I think that would be good. And then we'll get a few minutes for us in the plenary to make comments and to ask questions. So let's start with Ms. Victor. We'll give you 5 minutes to give us your input.
Okay, thank you so much. I also want to recognize the presence of our Chief Justice, who is actually doing a lot in South Sudan, and is also helping us as women associations in helping the vulnerable groups to access justice. So far, dealing with women, of course, because we are working with varieties, we work with a lot of women in different locations. Our office is actually centered in Juba, but we do travel to different places. Like recently, I have been in Magwi, and Magwi is this site of, it's actually near bordering Uganda. And the reason why we travel there is for us to also assess how women are accessing justice. So in the process, we discovered we have a lot of challenges or barriers in accessing justice for women, children, in whom our mandate is. And it is actually connected to the institution's visibility. This is one of the things, whether the judiciary setup is up to the grassroots level where our women can be able to access justice. And this is part of the difficult or the barrier that we got on the ground, where we get that there's no actually provisional judges at certain areas, like the example I'm giving in Magwi. But of course, we also acknowledge that at the center in Juba, or these big cities, like Malakal, we have like Torit, where it's actually like Yei, we have judges who are there. But of course, we acknowledge that there are a lot of areas that we have challenges in dealing with issues, and because as Federation of Women Lawyers, we are helping representations of women in this area. So visibility of this court is also a challenge for us to address some of the issues in terms of representation of women in courts. So one of the other challenge is the language barrier. As we also came from, we actually come from different diversity, and like we are 64 tribes. So like one of the presenters was noting that we are coming from different background, and judges are using Arabic. In the center, of course, it's good that the clients or the women there, they can access the language, of course, but coming out now to the rural areas, to the grassroots level is very difficult, because they also need judges who are also using their dialogue or maybe their indigenous language, which is actually one of the access to justice for them, because they do understand and they are satisfied with any decisions that come out. And this is one of the challenges. I think our Chief Justice is also doing his best to work on that. If we come to absence of legal aid service, as women, we are actually helping render legal safe service. Like we provide free pro bono service to women, but of course it's not actually to the standard, because we cannot cover the whole country. And we are expecting Ministry of Justice, which is actually mandated to provide a free legal service, to also help us as women organization, is also helping accessing justice in South Sudan. And this is one of the challenges that maybe Minister of Justice is also doing his part, but of course it's very slow. So though we are coping up, we are helping, but it's not to that extent because we cannot cover the whole population, and it's a challenge for us. So legal aid service is also one of the challenges that we are also seeing that the regional court will also address it, because it also comes to like, now for women who want to access the regional court, they will have difficulties because of there's no this pro bono service offered to them there. So the other thing is lack of enforcement of decisions. There's slow enforcement. We are not saying it's totally not there, but of course there's also slow due to other challenges attributed to it, which we all can work together to address. And the biggest challenge is awareness in terms of procedures. If, for instance, you have a case, what are we supposed to do? What are the procedural aspects? Are we supposed to turn into revenge instead of the legal aspect of it, following the legal procedures, or maybe because of the delayment, some people will opt to go for revenge. So these are some of the things that are attributed to like access to justice becoming difficult, especially for the women and the children. And I can stop here, maybe if there are additional things I will do later.
Thank you very much, Ms. Victor. Yeah, we've seen now the barriers that we're talking about for women in South Sudan. You can see the general issues we're talking about. Language are still very much alive. The issue of access to legal services. It's one thing to be able to go to get a just outcome. The question is, how do you enforce it? That's also another issue. We appreciate this context. Then let's now move to Ms. Andrico.
Thank you very much. I request that I stand on the protocol that has already been observed. It has been an interesting discussion for me as a legal aid service provider since morning. And what I just want to say is that all the barriers, as we have had them, disproportionately affect women and children as they seek for justice in the various courts. I'll quickly make reference to the United Nations Practice Note 9/3/2004. It does provide for various barriers to access to justice. But the one that stands out most for us as legal aid service providers is it speaks to gender biases in the court systems that affect women's pursuit for justice as a barrier. And also the lack of adequate legal aid systems. It also speaks to poverty, which forces people to avoid the expensive legal systems. And we all know that even when we speak about poverty, still women are at the lower, women are poorer than the men in the communities in which they live. Very quickly, the barriers have already been spoken to or addressed by my colleagues on the panel. But I'll just quickly refer to the geographical barrier. I'll make reference to the Busoga region that has over 40% of Uganda's population. It has 12 districts. However, it has 3 resident judges and only 3 legal aid service providers. That is serving 12 districts. And we all know that in that category of people seeking legal aid, women occupy a larger percentage. I'll also make reference to Article 13 of the International Convention of Persons Living with Disabilities, which states that justice systems must be designed and modified to provide equal justice to persons living with disabilities. We all know that there's insufficient disability inclusion. This has been mentioned in the morning and in this, I think, afternoon as well. Lack of sign language interpreters, and also sometimes the inadmissibility of evidence of people that are hard of hearing, and also people living with mental disabilities. There is a general lack of expertise within the judiciary. The lack of witness protection law is an impediment to the successful prosecution of cases. Limited adaptation to the justice systems, compounded by the high literacy levels. Limited information has already been mentioned, and the absence of a national legal aid framework compounded by the shrinking donor space. I think for legal aid service providers in this room, we all know what has happened with the closure of DGF. Over 93 beneficiaries of the democratic governance facility have been affected and have been forced to either tone down their services or close altogether. I fear to imagine what's going to happen to the justice seekers at the end of that chain. The criminal age responsibility, most children, especially in Arua and Chotera, where we have been doing juvenile justice work, do not have birth certificates, and yet they are required to verify age where their rights have been violated. Gender-specific barriers within the justice chain, allow me to briefly speak to this. General Recommendation 33 of the CEDAW, the right to access to justice for women, is essential to their realization of all the rights protected under the CEDAW. We've all been talking about how progressive the digitization of the court systems, the processes has been, but I just want us to reflect on the digital divide, the lack of infrastructure. It was mentioned as a barrier, but for us to interrogate the extent of that barrier. And that, again, disproportionately affects women, where we have 51% of our women, as 50% as the population of women in Uganda. Only half of those have access to phones. So I'm wondering if they have to, kind of follow up on their cases, how they are able to do this with a digital divide, lack of tools, and also lack of actual internet connection across the country. We need to also look at the burden of unpaid care that women face as primary caregivers that has trapped them in a vicious cycle of poverty and equally left them time poor. Insufficient prioritization of SGBV cases. There is an effort within the criminal justice system to address this. Our plea, or we implore the duty bearers to institutionalize this so that it moves away from just being a case of goodwill or that is available where they are judicial activists in the various courts. I'll just quickly also make reference to the plea bargaining. I also have issue with it. I think it is more victim-centered. It focuses more on getting these people out of the prisons, decongesting the prisons, and not on creating or providing remedies for the survivors. We also think that the process is generally gender blind, and there's been a study to that, and that we need to do something about it. I'll just quickly speak to the remedies. I think we need to mainstream gender in the administration of justice. We need to create an enabling legal environment, enact the witness protection law. It has been on the shelves for quite some time. Also pass the national legal aid law so that we can have many more people accessing justice from the state other than relying on civil society and NGOs. We've seen a growing promotion of people-centered justice. We would like that to be institutionalized, and we would also like to see the promotion of independence of national judiciaries. We are encouraging bar bench justice forums to help restore the confidence of the public in the judiciary. We also are imploring on the duty bearers to support proper judicial processes. In the past, we had the Paupers Act. I think that has now long become obsolete. Even the name itself is quite offensive. So I think we need like-minded organizations to lobby for an act that enables the prioritization of poor people's cases within the judicial systems. Lastly, I think we need to also work with the Judicial Training Institute. I saw the director here in the morning. There is need for us to recognize the intersect between customary justice practices and the formal justice systems. I think we need to train formal justice, the judiciary, train them on the customary practices, on how to align the two, or to find how to find the intersect between the two. We see that beginning to creep up in the jurisprudence. We hope that other judicial officers can take that up as well. At ESC level, we would like to see a lot more meetings like this, a lot more conferences, so that there is more sensitization on the role of the ESC court. And I think one last recommendation is for us to obtain express jurisdiction by giving effect to Article 27 of the ESC Treaty. When I say express jurisdiction, I mean the jurisdiction to hear human rights cases specifically. There is room for us to do this because this article provides that the court shall have such other original appellate human rights and other jurisdiction as will be determined by the council at a suitable subsequent date. To this end, the partner shall conclude a protocol to operationalize the extended jurisdiction. So partner states, I'm requesting that the partner states look into this. Let's have this protocol concluded so that the jurisdiction of the ESCJ is properly enabled to listen to human rights cases. Thank you very much.
Thank you very much, Ms. Enrico. Listening to Ms. Enrico and Ms. Victor giving us perspectives of access to justice in Uganda by women and also in South Sudan, I think you are struck by the commonality of the barriers and the challenges, but we've also gotten a few suggested solutions from legal aid, addressing outdated laws, the issue of training, the issue of more use of customary dispute resolution mechanisms, but we need to ask also to what extent are customs barriers to access justice for women. Thank you, Ms. Enrico. Then last but not least, let's hear Mr. Baraka.
Thank you so much, moderator. Everyone here should perhaps appreciate the difficulty I have to speak the last after these wonderful interventions. But allow me to bring in a certain anecdotal aspect of my intervention. Mr. Gimara, perhaps you have had one of the barriers that I would like to highlight, because in the examples that you have been giving us, no example for Burundi you have given to the audience. I think perhaps the barrier that you should have had is the language barrier, because our laws and everything is in French. And if I try contrarily to transpose this, the language become a barrier for Burundian. Let me start by the regional courts to access justice at the level of the East African Court of Justice. I can represent, and other lawyers can represent. I think even in the framework of regional integration, we will have perhaps also a chance that Ugandan lawyers, Kenyan lawyers come to represent Burundian, but also there will be a language barrier. I would like to emphasize on this, because at a certain extent, we would like a community, an integration that is brought until at the grassroots community. You understand that for ordinary citizens, the most ordinary citizens at the hill level, it will be a problem even to approach, to access justice at the regional level. I think even here in this conference, this is a barrier, because there is no translation in French. And I have seen Burundi and Congo as speaking French-speaking countries. Imagine that an ordinary citizen would like to know the work of East African Court of Justice, especially what happened during this conference, and they would like to listen to the recordings. That will be a problem for Burundian citizens. That is an important barrier to access to justice for Burundian at the regional level. And if I try to go at the national level, allow me to first start by a disclaimer. What is going to be said here is my personal opinion, and I apologize before the Chief Justice of Burundi if I say something which contradicts his opinion as far as access to justice in our country is concerned. Many have been said before, but I would like to highlight this thing that access to justice is not only about quantity, it's also about quality. Yes, we have the National Strategy on Legal Aid, which in my opinion allows ordinary citizens, vulnerable people, to get assistance by a lawyer. And I think that the government is also making some effort to try to enforce the legal aid with many initiatives and in cooperation with development partners. But in my opinion, what is there, I can compare this as a father who would like to give a loaf of bread to his child. And he waits. I wait that until you become more and more hungry, and I will give you that loaf of bread. I would like here to emphasize on the time between access to a lawyer in the framework of the legal aid. Yes, we have some people, children, women, and persons accused of crimes punishable of heavy sentences, who have been added in our law as the person that must have mandatory assistance by a counsel. But if they access to a counsel after a long time between arrest and the court decision, the court stage, in my opinion, that will be, it is not useless, but it is coming late. And when it is coming late, I think this has some negative bearing on the outcome. Because in my opinion, the earlier a person, a vulnerable, get access to a lawyer, I think this will also change the outcome. Then I would recommend here that in the framework of thinking of providing more legal assistance to accused person, I say accused person because I'm more concerned by the criminal justice. This should happen as early as possible. I mean, at the stage of arrest. And this morning we have been honored by the presence of the president of the African Court of Justice on Human Rights and People, who shared with us a framework of legal aid before that important court. What if we suggest that a a similar thing is institutionalized before the East African Court of Justice for those vulnerable people who are not able to afford legal fees. Another point I would like to stress on is, has been highlighted by my colleague from Uganda, is about enforcement. I'm also talking about reflecting on the situation on the ground in my country. Execution is a matter in which I think the government should think deeply on and try to bring, to amend, to bring innovation around it so that it can be streamlined, because in some cases, people can have good decision. They can have provisional release. They can have acquittals. But sometimes it is difficult to get execution of those decisions. And on this regard, I would like to recommend that the procedure of execution of decision should be rethought, and that more powers should be given to judges so that they can have control over the execution of the decisions. So there is a lot of things to say as far as access to justice and equality before the law are concerned. I'm happy that through the remarks of this morning, you have got important insights, and through the presentation and what my predecessor panelist has said, we have get a lot of recommendation. I would like to stop here and thank you all for your attention. Thank you.
Thank you very much, Baraka. Baraka really brings home this issue of language as a barrier to access to justice. You know, the community, when it and the initial three partners said so under common legal system, common official language, I think the challenge was not very big, but we see it every day in the court. Those parties who insist on defending themselves, let's say from like Burundi, from Rwanda, and now we have DRC, some of them who do not at all speak English, it's quite a challenge. And I think we cannot deny that it's something we really have to address if we are talking about access to justice. Like Mr. Gimara, Baraka also has emphasized the issue of quality of justice as an attribute of access to justice. He suggested what we also need to do about legal aid in the ESCJ, and also the same question of enforcement that keeps coming back. That's the issue, is not just getting the result, but also being able to enforce that result. Ladies and gentlemen, what I propose to do now is to give us a few minutes for purposes of questions, comments, and then we'll get back to Mr. Gimara to respond, and I will also give the panelists 3 minutes each to hand to whatever will have come from the floor. So let's see how I'll pick Justice Chiberion, not because he's my neighbor, but because I saw his hand first. Justice Rivoire, Justice Charles Nyawero, Justice Charles Nyachai. Yes, our brother there, I cannot, yes, right? Okay, so then let's see. Chiberion 1, Rivoire 2, Nyawero 3, Nyachai 4, 5, 6, and 7. Let's start with those 7 ones, please.
Thank you, moderator, and thank you, Gimara, for the presentation and the moderators. Mine is really to Mr. Gimara. Mr. Gimara, you identify procedure, the difference in rules of procedure in the different
different countries, difference in the different countries as an impediment. I agree with you, yes, that there are gaps, especially in Uganda, in our rules of procedure, and there are areas for improvement. But then, looking at it from the regional level, my view, and I think, the position is that each country tailors its rules of procedure to meet their local circumstances. What pertains in Burundi may not really be a big issue in Uganda. How then would you want this to be harmonized? Are you thinking of rules of procedure in the region, in the various countries, that would be more or less similar so that we are able to have processes that are similar? And I thought that the rules of procedure really are for domestic courts. Now, how does this impede access to the regional courts, more so to the East African Court of Justice? Because the court has its own rules of procedure. Maybe what we would be thinking is, how do we make the rules of procedure of the regional court be more understood so that it enables access? Thank you.
Thank you. Livoa.
Thank you for having given me the floor. I do first congratulate the presenters for their nice presentation in light of their access of justice. I will mention other two factors which are compatible with the principle for access to justice. One is awareness. The second is sensitization, training. These can be other factors that I add on. But how to handle this? We have to take into account first the procedure applicable at that particular international court like ours. Secondly, we have to look at the jurisdiction and the jurisprudence of that particular international court. But we have to link this also with other international courts. In order to do this smoothly, I think a good model can be traced even in the jurisprudence of the ESCJ, as well as in the civil law countries. Here, I put forward the notion of jurisdiction. It is in the civil courts approaches that they define clearly which kinds of jurisdiction a court have to look at in order to address a particular matter and to come up with a decision which will be final and conclusive in the interest of the parties. The first one they identify is ration personae. That is the competence that is vested to a court to hear a particular person who has access to it. The second one is ration materiae, whether the subject matter is in accordance with the Constitutive Act embodied in that particular act so that it can exercise that particular jurisdiction. The third one is ration temporis. And also this kind of sequence has been developed by the African Court.
Judge, please try to be very direct so that we do not have another presentation, yeah?
Yes, I am getting there. Then, if you address this, you see that there is nothing which is still hanging. The one who has accessed the court can have remedy. And I took on not taking into account the jurisprudence of the court that a notion of jurisdiction can be raised at any time by even suo motu by a court. This will help the users of the court to waste the time, will avoid the delay, which is a barrier to access of justice as well, because justice delayed is justice denied. We went further even to say that it is even justice buried if it is delayed. And then another barrier, if you take into account all these kinds, will be also the question of backlog because of delay. If there is a mechanism to avoid the backlogs, this should be developed. But without saying so much, we have to look at the procedure, sensitization to the procedure, and jurisprudence and the jurisdiction of the court will help the users of the litigants at the East African community level. But lastly, then it will be those was contribution a bit. My question, which is very short.
Sorry,
very
Judge,
short,
Judge,
it will
no,
not
we
take
can,
even
please.
1 second. How amicus curiae is dealt with? Is it taken as like a party or not? If that is yes, is amicus curiae entitled to costs? That is the end of my intervention. Thank you.
All right, thank you, Judge. Charles One, please, I will cut you short if you go beyond. No, sorry, number three.
Yes, thank you, moderator.
Yes.
My congratulations to the presenter and the panelists. Presentation has been excellent. I've been following it very keenly, and I feel satisfied. So I'm reacting to the panelists. I will begin with the concerns of Baraka Fetia, especially the problem of the language as a barrier. This morning, people have talked about language as a barrier. At the level of the East African Court of Justice, I can't deny that there is language is not a barrier. It has been a barrier, but we are on the way to the solution of the problem. Even before that, we have heard cases where parties were speaking French and there was translation. Even we had one case also where parties spoke in Maasai and we had translation. So language has never been a barrier in the history, but it could also be a barrier in facilitating and accelerating the understanding of the system. Concerning access to justice, I will use example from the South Sudan. The Chief Justice is there, he will speak, but I'm speaking in my capacity as the President of High Court of South Sudan. Access of justice has never been a problem in South Sudan because if you look at our court structure from the civil and criminal procedure, the courts begin from the top level down to the village level, which we call FIAM. So our structure is that you have first-class magistrate, second-class magistrate, and third-class magistrate. The third-class magistrate operate at the village level, which we call FIAM recently. And it has been like that maybe for 200 or 300 years. It has been like that. So there has not been a problem of justice because at the village level, which is the FIAM, at the level of FIAM judge, it is managed by lay magistrates who are actually natives of the same area. But I, as a president of High Court or any other judge of High Court, gives judicial power to that panel of lay magistrate to exercise judicial power, and they use the customary law, the law of the place. If the person is not satisfied with what the panel has done, then he or she makes appeal to the first grade magistrate. Then at this time, this is where it takes the form of formal justice, which has been mentioned by Mr. Adrico. And so the interaction, the intersect, which Adrico is talking about, is available in our system. You begin at the customer level, where everybody knows what the law is because everybody is acquainted with the custom. And then when the custom fails to provide the justice you want, then you go to the formal justice through the first grade magistrate, and then from there it goes to the Supreme Court. I mean to the High Court.
All right,
Supreme
wind
Court.
up, wind up.
In addition, okay, I will wind up. In addition also, if there is any case that needs, for example, public attention or cases of public interest, the Chief Justice forms a special court in which the head person is a judicial officer of the first class of High Court, and then there are lay magistrates to come and attend in order to communicate with the people better. So access of justice actually, in theory, is there, but practically, as far as South Sudan is concerned, has never been a problem, except only we want to improve it. If there is a way of improving it by increasing the number of judges and the number of special courts. Thank you.
All right, thank you very much. Okay, let's have Charles too, then we'll get to the brother just behind you, please.
Thank you. Thank you.
We are coming to you next. Charles?
Yeah, okay. Thank you very much, my lord, and thank you to the presenter and the panelists. I just want to make a comment relating to the issue of quality of justice, which both Mr. Gimara and Mr. Baraka, as you baptized him, adverted to. And I want to comment on that from the perspective of the court itself, because that's where the justice is expected to be delivered from. To what extent, Mr. Gimara, or any of the panelists, do you think that there is a problem in that nobody seems to have stopped to actually seriously consider the issue of now 7 countries with at least 2, if not 3, different legal traditions, and how that plays out at the court. Since this is a conference, you'll allow me to give some examples. For example, people from the civil law tradition, what we from the common law may take for granted, and it's commonplace in our practice, like what an affidavit is, you find that this is foreign to somebody from the civil law tradition. And they're supposed to work together to deliver justice. To what extent do you think that perhaps we need to take a step back and see how can we try these countries or these legal traditions to see how they can be blended, so to speak, to deliver justice. Now, on the same issue of the quality of justice, allow me to disagree with my brother Justice Nyawelo on the issue of language at the court. 2 things I want to say, and then I finish. My Lord Judge President, tomorrow, DRC could appoint a judge to the First Instance Division who doesn't speak 1 word of English, and they would be within their right to do so. Is the court equipped to deal with that in a manner that will ensure the delivery of the right quality of justice? The examples that my brother, Justice Nyawelo, gave, how we have dealt with translations where there are people coming to court who don't speak the language of the court. With respect, in my view, these were ad hoc solutions. In the one he referred to about the Maasai litigants, which we were just lucky that a member of staff of ESCJ spoke the Maasai language and could give some level of translation. With respect to her, we don't even know whether the level of translation was correct. The point I'm saying is that I'm not sure that we have given, for example, that issue of language sufficient attention so that we ensure that the quality of justice that we are delivering is the right quality of justice due to the citizens of East Africa. Thank you, sir.
Thank you very much. It's not surprising Charles 1 and Charles 2 who never agree. Our brother behind there, please. Yes, it's your turn. Yes, yeah, the gentleman, yes. Yes.
Thank you, Chair. My name is Jean Bosco Butasi. Jean Bosco Butasi, the former principal judge at the East African Court of Justice. First and foremost, allow me to commend Gimara for his bright presentation. And the theme is access to justice and equality before the law, removing barriers at national and regional courts. That allows me to go back to you, to put on you a clear question. As a lawyer, especially, appearing before the East African Court of Justice and at a national level. From my perspective, access to justice is not only limited to file the case before the court, to see that my case is heard, to see that the court is delivering a judgment. But the ultimate goal is the execution of the decision of the court. So as a lawyer, appearing before the East African Court of Justice, as well as at national courts, what is the state of the execution? Because it is included within the parameters of access to justice. My second question, and the last one, from this morning, the first presentation, you remember that the presenter recalled the case of Ocampo before the ECOWAS court. I also remember that within the East African Court on Human and People's Rights, there was what they called, when some pattern states were withdrawing from the African Court, judicial tsunami. So don't you think maybe Mr. the President of the Court could answer my question, or Gimara, don't you think that there is a need for a survey within the pattern state just to know the awareness and perception of the court, of what the court is doing for the citizens of the pattern states, at least before the third or the fourth Judicial Annual Conference? Because I got the impression, that they said, I even heard this morning that there is a trend from the court of taking over the competencies of national courts. How do you take that? It is not an encouragement. Don't you think that there is a need for a survey to be conducted by the court? At the same time, they will, he even said that within the pattern state, a lot of people are not aware of the mandate of the court. That survey will sensitize the politicians about the benefit of the court, because they just think that it is a foreign court. No, it is a national court. because every partner state ratified the treaty and has domesticated the treaty, has even appointed judges before those court, that court. Then it is their court. How do you think? I finished. Thank you.
Thank you, Judge. Appreciate. We have two more people. Please, let's be as focused as possible. Number 6.
Thank you. My name is Gilbert Olanya, the Member of Parliament from Uganda. I would like to appreciate Gimara Francis for a wonderful presentation. And I have only one concern. You elaborated very clearly about the access to justice. And you gave various barriers to access to justice. To me, the case of Uganda, I feel political influence is one of the barriers to justice in this country. The case in point, many of our judges, the way I look at it in Uganda, they tend to lean so much on political influence. For example, in Uganda, 1 year ago, President Yoweri Museveni gave orders that there should be no bail for anyone charged for murder. And as a result, 2 members of parliament were arrested, charged for murder, because they are in opposition. Right now, they have taken more than 1 year in prison. They are just rotting in prison. I would like to appreciate the prison officer who spoke. It seems judges in Uganda, they lean majorly on politics and they work under orders. My question is, how is the East Africa Court of Justice working, putting up measures never to be influenced by political decisions? It's quite dangerous, the way I look at it in this country. And the moment we allow politics to sway our ideas and opinions as judges, automatically we are doomed. We call for independence of the judiciary. Let political wings do their own jobs. I beg to move.
Thank you very much, Gilbert. Then the last contributor for the plenary.
Thank you, Chair. The panelists, my lecturer, Gimara, he can't even remember. My name is Ekudo Tom Julius, Member of Parliament for Uganda. My concerns are more or less same to what my brothers just said, state interferences. Here in Uganda, it is too much. Even if you have stolen billions and you go to somebody to kneel down, you will be favored. It is also a barrier. How are we going to handle that? The other thing I would like to say is the issue of language barrier, and also in the courts. How are we handling the people in sign language? I have been entering into courts, but I don't see, in the case there is that case where somebody is supposed to be interpreted by sign language. That provision, I don't know whether it is there. And then in the case somebody has committed an offense outside Uganda, the case of Congo, you know, I was at a university. One student from Congo could not write a sentence, but give her exam on the French, she will make it 100%. How are our people? I know our people are suffering maybe somewhere in some countries. How are they helped? I thank you.
Thank you very much, Mheshimiwa. Yeah, a very important point there about access to persons able differently, together, of course, with the other issue that has been raised by your colleague about politics and as a barrier to access to justice. We are doing very badly in terms of time. We'll have to stop there, and I'll now give the opportunity to Mr. Gimara. You'll be as precise as you are, and then our other colleagues, if anyone has anything to add to what has the questions or the comments that have been raised. Thank you.
Thank you, Chair, and indeed the distinguished members who raised questions and made comments, the same is received with gratitude. Justice Cheborion, the point I was making on procedures is that it is still couched in legalese. There's always room for both at the national and the regional courts to further simplify this. You recall, and you know very well, Judge, that our civil procedure rules, you very well remember a book we used to do in the university, Mula, you know, on civil procedure. Mula was an Indian textbook. So the rules came from Europe, imported through India. And that has remained with us for a very long time. So my point is that these rules, we still need to continue working through them. We need to continue innovating. We need to continue making them much simpler and, you know, accessible for the people of East Africa, both at the national and regional court. So the point was really that we can continue to do much better to make them more user-friendly. I have an example, for instance, the Human Rights Enforcement Act of 2019 in Uganda, where it was simplified to such an extent that they put in the procedure there that you can access court not through an application, but even by letter, an ordinary letter. That would definitely help a category of people who don't understand anything to do with an application, a notice of motion. The moment they read and they say, I can come to this court by an ordinary letter, then be it. So today it appears that unless you get somebody to explain to you what a reference is, you know, you will have a lot of difficulty in accessing the court. So that is the point I'm saying. The rules are still couched in legalese, both at a national and also at regional courts. There is room definitely to innovate. There's room to do better. And that was the appeal of my paper in regard to that barrier. There was an issue somebody asked about amicus curiae. Is it a party? Definitely not. It's not a party in the sense that they have a dispute or seeking a question for the court to answer. I think the rules are quite clear on that, the nature of the application, and they come to court as a friend of court if court is persuaded indeed that they meet the criteria that the rules have laid down. My point was that there's very good jurisprudence from the ESCJ by, you know, continuously they have been very accommodating, you know, much more than the national courts, you know, on issues of amici, and that in itself enables access, because sometimes when you admit, you know, friends of court who have the knowledge and the expertise, then it improves that justice outcome. And that spirit that the court has, I think in many of the cases at the ESCJ, they have granted more as opposed to denying. And it is that environment that we see as a positive trait that can be, you know, replicated across national jurisdiction as an example of a good practice. Then there was, I think, this Justice Nyachai on the issue of the problem to do at the earlier stage of admission of this country versus the tradition, the legal traditions. That's a big problem. And I mean, at the East Africa Law Society level, we even contemplated that we needed these countries to satisfy the test that the treaty, puts. And if we thought that at one point we should actually file to ask whether the admission of certain countries satisfies the test in the treaty. But debating this internally, we thought that looking again to be practical, that these countries are probably benefiting more by being in the EAC than out of the EAC. And that is something we have seen in terms of more respect for the rule of law, in terms of developing ethos that, promote good governance and, and rule of law. A good example, we all are happy that the Kenyan election dispute was handled within that rule of law umbrella. Tense as it was, at the end of it all, the decision of court was respected, and that is the essence of the rule of law, that even in as much as you don't agree with the decision of the court, you will respect it and wait to fight another day. I think that this, by Kenya just being a member of EAC, certainly other countries are watching, and these practices can eventually percolate and build on the body of rule of law and good governance. But perhaps the point, Justice Nyachai, is that we need to go and do much better. Because if they come in and understand the treaty and the applicable law relating to the EAC community, they need them to be helped, they need to be facilitated in terms of capacity building, in terms of, training, in terms of enabling them, to be equal participants in the justice platforms and as well as other platforms across the EAC framework, legal framework. So I think capacity building is certainly very, very important. But we also know that at our level as ELS, we have, we have that kind of intersection. We do a lot of legal aid for some of our friends who want to file cases from those countries. And we know that after 2 years, 5 years, they will become much better and they will run with the cases on their own. So it is a work in progress. It's not easy, but I think that it is better that they are in the community as opposed to being out of the community. Execution, the legal framework for execution of the decision is not very strong. It is considered, but there's been just, again, out of not wanting to look as the bad man or woman in the community. For one reason or the other, the countries have been very respectful of the decisions of the court. Even as tense as the Katavazi situation was, eventually there was compliance with that decision, even without execution. So we have seen that perhaps not wanting to look bad in the community has in a way enabled countries to respect the decisions of the court. And for us, that is a positive. As to whether it ought to be strengthened, I think yes, there is a need to look at it in future to see that execution can be strengthened. But execution is not only a problem at the regional court, even at the local level, there are many problems related to execution of judgments, even at a national level. So it is a problem that we have. It is a problem that we should be looking for solutions by all stakeholders. Then there was the need, whether there is a proposal to carry on a survey. Maybe yes, maybe not. But I can confirm that just from looking at the number of cases filed in the ESCJ over the past few years, I think now, if you look at the cases, there are really many. For me, I see the number of cases as a vote of confidence in the court, that, people are beginning to want to actually go to the ESCJ, because the ESCJ also, in one way or the other, has developed a philosophy that is very clear on issues to do with rule of law, on issues to do with good governance. And I think a very consistent philosophy is helping every stakeholder appreciate that when it comes to matters of rule of law and good governance, there is a sense of predictability from the court. And I think that this is something that the court should maintain in terms of philosophy, because then even the partner states know that, on this issue, the moment it goes to EACJ, then there is, based on clear precedent, this is how the court will rule. That in a way has helped the court, because the current court stands on the shoulders of people who have, resolved those matters with clarity, and in a way brought a lot of certainty on these issues. I think that for me, that philosophy must be maintained, and in a way, I think for people who need to know that because of that, then also the issues of looking at the decisions of the court, I have not, felt that or seen that political pressure bear more directly like we see in domestic courts. I think that overall, the political players, for now, since Anyang' Nyong'o maybe have given some space to the court. And I believe that because of that space, the court has been able to churn out the jurisprudence in the way that they have done. And we owe this court a duty. The MPs are there on issues of political interference, and indeed the judiciary, that the independence of these courts is not only on the judges, but it also depends on us, the stakeholders, importantly on you, the MPs, who have the authority to speak for the courts. The judges don't speak for themselves, but we all understand that the rule of law is something that we all need. We all need it because it is the lubricant for the protection of society. It is the one that we all call to when we are caught or in a corner. So it is not only the duty of courts to protect this. I think that all of us, the MPs, even those in the room, you have much more power than us ordinary citizens to protect these institutions and enable them function in accordance with the mandate that has been given to them. So I think, Chair, those were the issues that were raised. Thank you.
Thank you very much, Mr. Gimara. Baraka, 1 minute.
Thank you so much. Perhaps I would like to come back to the quality of justice. That was also a concern that has been raised by the audience. I think we have been, because of the constraint of time, we have been summarizing about the quality as an element of access to justice, because there is a lot of things to say. For example, a justice system where corruption is rife, that is not a justice system that is able to provide the quality justice. And at this extent, I think everyone can assess at the national level what is the rate of corruption within the justice system. And on also quality, I think there is a problem perhaps which is proper to my country, to Burundi, and also this is my own opinion. When I try to observe, to see how the infrastructure of our justice system is made, in terms of experience of judges, and if I try to compare with the experience of, for example, other the lawyers, I note that there is a kind of imbalance between experience of judges and experience of lawyer, because some lawyers, when they are getting more experience, they leave the judiciary and they come to practice as some judges, they leave the judiciary and they come to practice as a lawyer. while it was a time for them to use this experience for many years, and we found a situation where we have judges with experience, yes, but in front of lawyers who have been first judges and who have left the judiciary. I think this also gives an idea of, in a certain way, on the quality, and let's suppose that the lawyers perhaps will help the matter of quality of judgment. But I think there is also, it's a matter of also capacity building within the justice system, and I'm happy that we have a center which is there for training of personnel in the justice system, and all of those things pertains to quality and many other things we can say about that. Thank you.
Thank you, Baraka. Ms. Victor, strictly 1 minute, please.
Okay, thank you so much. I would like to register my thanks to the organizers and the East African Court of Justice for inviting us, especially Federation of Women Lawyers. We are so happy, and we would like just to make 2 requests. One is, if possible, the East African Court of Justice should empower the local organizations at the grassroots level so that they can disseminate information about the court, the treaty, and accessibility, because sometimes they also have a different understanding that this court belongs to Uganda or something like that, or maybe it is only accessible to Uganda. So it's like an opportunity, since it's one of our objectives in the organization. The second request is for accessibility, for justice to be accessible. We also want registrar to be established, because in South Sudan, we don't have East Africa registrar. For instance, if you want to come, you come to Arusha, and this is only maybe possible for those who are financially capable. So if the registrar is there, it's also good, it will facilitate. So I will just end here for purposes of time. Thank you so much.
Thank you very much, Ms. Victor. Ms. Enrico?
Thank you very much. I think on the issue of disability rights inclusion, I can only implore the duty bearers to better resource the judiciary so that they are holistically equipped to be able to speak to the gaps that we already mentioned. But also, as my colleague has mentioned, I have an appeal to all the justices in the room for you to exercise your judicial activism. There is a dividend that we realize as court users, as service providers. We've seen judicial officers that have moved court to the communities. We've seen judicial officers that have designated days for legal aid cases. I think if we can start with that, then we can ably advocate for a case for these to be institutionalized and properly funded. The last comment is to continuously interrogate how to navigate the legal pluralism that we have been talking about since morning. We live in societies where customary law exists, so how to navigate the intersect and ensure that in both in the dispensation of justice, both from the customary perspective and from the judicial perspective, that we take cognizance of that in order to deliver access to justice. Thank you very much.
Yeah. Right. Colleagues, we really have to bring these proceedings to an end. It's already past 6 o'clock. We have taken 3 hours from your time, but I think from the deliberations, it's very clear that this is a matter very close to our hearts. It's extremely critical. I do not even think we have done justice to it. I can see so many hands, but as we were told in the previous session, we still have some networking to do. We can continue this debate. So please, let's appreciate Mr. Gimara for his presentation and our three panelists, Baraka, Ms. Victor, Ms. Andriaco. Thank you so much for the time you have taken to prepare and to present your views, which have resonated very well with our audience. So thank you so much. I will hand us over to Christine to tell us what we need to do. And again, thank you so much for your contribution, for your patience. Asante sana.
Thank you, Honorable Justice Kathurima, for steering this session very well. I also want to thank the presenter as well as the panelists for their very interesting contributions to this discussion. But mostly, I just want to thank the participants who have stayed with us to the very end of today's activity. We thank you very much. It only tells us that this is quite interesting so far. But tomorrow we have even more interesting discussions. And what the session tomorrow, the first session tomorrow is the role of national and regional courts in bridging the access to justice gap for cross-border trade disputes. I wish to mention that we shall have the AG of Uganda as a panelist. We'll have the Executive Director of the East African Business Council. We'll have Honorable Sheila Kamara, an MP, as well as Lady Justice Monica Mugeni, a former judge of the East African Court of Justice on this panel. With that, I also want to request that presenters, please share your presentations if you haven't, and please do that tonight, because as you'd understand, your presentations are the ones that inform the panel discussions. And in the interest of access to justice, I would like to request if there's anybody here who wishes to have translation services by show of hands. Okay, so I have one in French, for French, and another for Arabic. Thank you very much. With that, I wish to remind you that we shall have our COVID tests taken tomorrow morning, and you shall receive the guidelines on where to go in the morning. I wish you all a very good evening, and may you get enough rest to get you all set for tomorrow's session. Have a good evening. Thank you.
Right, thank you. Thank you so much, my brother.